Dear guest.
Cari ospiti, illustri oratori, signore e signori, benvenuti a questa conferenza internazionale sui diritti d'autore che si svolge qui al Parlamento europeo a Bruxelles. Esordirei ringraziando il gruppo FDD e il Parlamento europeo, in particolare l'onorevole Adinolfi, per avermi dato l'opportunità di presenziare questa conferenza. Poi ringrazio il personale dell'onorevole Adinolfi per il suo supporto. Ringrazio anche gli oratori e i traduttori, dice il relatore, e anche ringrazio per essere stato nominato anfitrione di questa riunione. Benvenuti a questa riunione intitolata Nuova legislazione sui diritti d'autore nel mercato digitale. Dovremmo pregare il relatore di rallentare. Innanzitutto inviterei l'onorevole Adinolfi, membro della Commissione Cultura del Parlamento Europeo, a presentare il suo discorso di benvenuto.
Grazie a tutti di essere intervenuti, grazie a quanti hanno reso possibile nel mio staff l'organizzazione di questo evento, grazie ai professori che hanno gentilmente accolto l'invito a partecipare. Vorrei prima di tutto dare una piccola comunicazione di servizio. Come sapete abbiamo l'allerta gialla per problemi noti e quindi ci hanno impedito di organizzare il piccolo rinfresco che sarebbe dovuto tenere alla fine del convegno, e quindi me ne scuso, anche se era stato scritto nel programma. Purtroppo ci hanno detto che non era, insomma, opportuno, quindi me ne scuso con tutti. L'idea di organizzare questo incontro nasce prima di tutto dalla necessità di coinvolgere maggiormente gli attori protagonisti, nonché i cittadini. Come sapete, noi del Movimento 5 Stelle siamo molto sensibili al tema della trasparenza e soprattutto della partecipazione democratica. I cittadini, come al solito, sono esclusi non solo da ogni processo decisionale, ma anche dalla più semplice informazione, e il copyright, così come tanti altri temi, soprattutto quando si volgono in chiave europea, sono percepiti dai media come un argomento di nicchia che interessa soltanto gli addetti ai lavori, e quindi purtroppo troviamo pochissimi spazi sui mezzi di comunicazione di massa. E invece il nostro auspicio è quello di rendere la discussione più trasparente possibile, di coinvolgere il maggior numero di cittadini, e in questo le tecnologie ci vengono incontro, e infatti abbiamo organizzato un web streaming per chi volesse partecipare anche dall'Italia. Purtroppo ci siamo resi conto che anche le prassi di lavoro del Parlamento europeo non aiutano lo sviluppo di una discussione democratica. Mi è dispiaciuto constatare oltremodo che per esempio la discussione che si è avuto in Commissione Cultura durante la presentazione della mia opinione è stata purtroppo sacrificata e tagliata di netto, perché l'agenda era troppo piena e si avvicinava l'ora di pranzo. Ecco, io questo modus operandi non lo condivido, soprattutto per un tema come questo, che è particolarmente delicato e che necessita invece ancora di più una discussione democratica, affinché ci si possa spiegare e si possano esplicare tutti i punti di vista. L'importanza di questo tema ci è stata confermata anche dalla richiesta di numerosi incontri con le lobby. E immagino questo sia prassi, per noi è nuovo perché, come sapete, siamo appena arrivati al Parlamento europeo, e devo dire che c'è stata una notevole pressione anche su di me, e immagino come c'è stata su di me in quanto relatrice, c'è stata anche su tutti gli altri deputati della Commissione. Ecco, questo dibattito invece dovrebbe essere esteso, trasparente, aperto. Non voglio che si parli soltanto negli uffici, nel chiuso dei nostri uffici, non soltanto nelle commissioni, ma in tutte quante le sedi possibili. Permangono purtroppo, come ho detto, alcuni aspetti oscuri. Sono rimasta assolutamente allibita quando ho appreso che per un cavillo di interpretazione del regolamento del Parlamento europeo, non si è provveduto a registrare i voti di un altro altrettanto importante opinione che riguardava invece un'altra direttiva, la IPRED, e nello specifico si trattava dell'opinione del deputato Raymond. Ecco, in questo caso, nonostante la votazione fosse stata alquanto controversa, perché non c'erano stati degli emendamenti concilianti e anzi questi emendamenti hanno stravolto talmente tanto l'opinione che si è deciso cioè che Raymond ha deciso di ritirare il proprio nome dal proprio lavoro. Ecco, nonostante questo, non si è ritenuto necessario che i deputati ci mettessero la faccia e che quindi il voto fosse registrato. Ecco, secondo me questa è una sconfitta della democrazia, perché noi siamo qui come rappresentanti dei cittadini e quindi quando prendiamo delle decisioni dobbiamo metterci la faccia semplicemente, dobbiamo essere trasparenti. Nessuno di noi ha interesse a distruggere posti di lavoro, nessuno di noi ha interesse a distruggere aziende, anzi, proprio per la crisi economica che ci sta, che affligge tutti i paesi europei, il nostro interesse è quello di favorire la creazione di una nuova economia, favorire gli autori, proteggere maggiormente gli autori, i creatori di tutti quanti i paesi europei, i grandi e i piccoli, e soprattutto realizzare un mercato unico digitale che sia vicino alle esigenze dei consumatori. Mi preme della mia opinione sottolineare soprattutto 3 punti. Una definizione unica, la necessità di avere una definizione unica di pubblico dominio, con delle regole chiare, uniche, trasparenti, sui tempi di diritto d'autore, che non limiti la conoscenza la circolazione della conoscenza e che non limiti soprattutto la cultura in ambito comunitario. Secondo punto, ritengo che sia necessaria l'obbligatorietà delle eccezioni per quanto riguarda almeno l'educazione, la ricerca e le biblioteche. E infine, terzo punto, credo che occorra rivedere i principi di responsabilità degli intermediari, cioè stabilire che i provvedimenti inibitori previsti dalla direttiva non contrastino assolutamente con quanto stabilito nella Carta dei diritti fondamentali dell'Unione Europea, nonché della CEDU, e che soprattutto queste inibitorie vengano disposte dalla magistratura. Assolutamente non ritengo che sia possibile che esse vengano disposte da autorità amministrative. E terzo, che i provvedimenti riguardano soltanto i clienti dei provider e non i servizi forniti da terzi. Ora, naturalmente sono contentissima, ringrazio ancora i professori per aver risposto al mio invito a essere venuti qui. Abbiamo invitato i migliori esperti del settore e sono sicura che ci consentiranno con la loro presenza un dibattito al più alto livello possibile, e io stesso sono ansiosa di sentirvi e di ascoltare il vostro contributo, che sicuramente sarà prezioso. Grazie.
Thank you, Mr. Adinolfi.
Grazie onorevole Adinolfi per il suo discorso di benvenuto. Parleremo dunque del presente e del futuro dei diritti d'autore e il modo in cui noi oggi condividiamo le informazioni, esprimiamo la cultura. È un modo molto diverso rispetto a un secolo fa. Per esempio, oggi le biblioteche sono molto diverse rispetto a quello che erano 10 anni fa. Stesso discorso vale nelle scuole e università, dove gli allievi utilizzano sempre di più il multimedia, facendo presentazioni magari che contengono nelle classi digitali materiale coperto da diritto d'autore. Il diritto alla circolazione della cultura, le opportunità per ogni cittadino dell'Unione di poter accedere alle fonti di informazione, tutto questo deve avvenire nel rispetto degli autori e va considerato come un diritto fondamentale. L'Unione deve garantire questo diritto a tutti i cittadini, con la giusta protezione per gli autori. Eleanor Roosevelt, grande avvocata dei diritti umani, affermò: dove i diritti universali cominciano? Nei piccoli posti, nel proprio quartiere, nelle scuole, in fabbrica, in ufficio. Ogni dove, ogni uomo, donna, bambino cerca parità in termini di giustizia, opportunità, dignità, senza discriminazioni. Se questi diritti non hanno significato in questi posti, sono senza significato anche altrove. Pensiamo al contenuto condiviso grazie ai media sociali che rendono questa condivisione sempre più agevole. Andros, anzi il vicepresidente dell'UE, ha detto di recente che la regina Anna del Regno Unito 300 anni fa diede il diritto di fare copie, e a tutt'oggi questa stessa mentalità sembra persistere 3 secoli dopo, in un mondo che intanto è già divenuto digitale. Il Parlamento europeo discute su come si può arrivare a una riforma dei diritti d'autore. La riforma è in gioco dal 2001 ed è diventato un vero e proprio groviglio, quasi un incubo, a causa dei veto incrociati delle parti interessate quando si cerca di cambiare il quadro esistente. Ma adesso abbiamo l'onorevole Reda che è incaricata e abbiamo l'onorevole Dinolfi che pure lavora nella Commissione Cultura e sentiremo i loro interventi, ma uno dei grandi temi scottanti è la mancanza di armonizzazione nei diritti d'autore. Non c'è un codice europeo unico o ancora un brevetto europeo, un marchio europeo in questo senso. Di conseguenza i lavori, le opere di ingegno sono protetti da 28 diritti differenti, i singoli diritti nazionali. Praticamente vuol dire 28 sistemi differenti. Un unico titolo europeo potrebbe proteggere più attori, soprattutto i piccoli attori, in maniera uniforme e unica. Günther Oettinger disse in un chat Twitter: abbiamo 28 regimi di diritti d'autore nell'UE, ma questo non risponde più alla realtà. Quindi inviterei a questo punto il professor Marco Ricolfi per la sua presentazione. Il professor Ricolfi interverrà andiamo verso un nuovo titolo di diritto europeo unico, quadro concettuale. Marco è professore in materia di diritti d'autore e alla facoltà di diritto di Torino e ha fatto parte del gruppo esperti d'alto livello dell'UE per le librerie digitali. Prego, Marco, hai facoltà. Posso avere la prima diapositiva? C'è un posto dove posso premere o lo fate voi? Comincerei allora con questa. È un onore, un piacere essere qui oggi. Ringrazio l'onorevole Adinolfi per aver organizzato questo nel maggio del 1990. 25 anni fa fu la prima volta che ebbi occasione di parlare al Parlamento europeo e parlai di biotecnologie in plenaria. E non sono poi così vecchiotto. Allora, di cosa vi parlerò oggi? Cominciamo dunque con il primo lucido. Eccolo di fronte a me, molto bene. Di cosa vi parlerò? Unico per i diritti d'autore. Ma abbiamo due modi di percepire il concetto, alquanto differenti, e vanno mantenuti separati ai fini analitici. Potremmo poi riamalgamarmi alla fine. Comunque, cominciamo dal primo. parliamo appunto dei due leitmotiv soggiacenti l'idea del titolo unico per superare la territorialità. Io sono membro della Società Europea per i diritti d'autore, mi aveva inviato una lettera qualche giorno fa al signor Oettinger, commissario europeo, e adesso è il momento di avere una legislazione sui diritti d'autore non in 28 stati separati, ma sull'Unione Europea nel suo insieme. Dobbiamo valutare i pro e i contro di questo concetto, dicevo, e intendo dire con questo che c'è un versante digitale alquanto a sé, che va visto come una questione a parte, alquanto differente. Quindi mi soffermerò dunque sugli aspetti dettagliati dell'uno e dell'altro e poi cercherò di vedere dove si può conciliare i due in una sintesi. È importante questa sintesi, un momento importante perché il motivo per cui siamo riuniti oggi è che viene discusso l'aggiornamento di varie direttive, tra cui la direttiva di applicazione. Quindi dobbiamo riflettere sul quadro allargato in cui si cala la questione dell'aggiornamento della direttiva sui diritti d'autore, perché con una direzione chiara anche i dettagli vanno al loro posto. Se manca una rotta chiara, e il più forte a prevalere, ma non necessariamente il migliore. Prossimo lucido. Da dove proviene questa idea di un codice unico per i diritti d'autore? È un'idea che circola da qualche tempo già. Un primo documento di riflessione della Commissione europea, alquanto un regolamento, non una direttiva, un regolamento di creare un codice per i diritti d'autore per gli allora 27, non ancora 28 Stati membri. Gli studiosi hanno considerato questa una buona idea. Di recente un libro parla delle possibilità. Il gruppo ISI era molto influente di Hugenholt, o se pensiamo anche all'Istituto Max Planck in Germania, come altro think tank che pure ha pubblicato un libro sei o sette pagine in cui si pone l'interrogativo se non è opportuno avere un codice unico. Insomma, il mondo accademico da tempo ci riflette. Il progetto WIDAM è stato un primo esercizio di stesura, un'iniziativa olandese di Hugenholt che ha visto riunito in circa 20 volte un gruppo di esperti, appunto, che con uno spirito aperto hanno ravvisato questa possibilità di comporre uno strumento giuridico che potrebbe essere utile a livello nazionale. E perché dunque questi sapienti si sono riuniti per discuterne e rifletterci sopra? C'è una spiegazione molto ovvia, forse non la più corretta. Abbiamo l'impressione che dobbiamo colmare una lacuna nei diritti d'autore, facendo quello che si fa in altre, come si fa in altre aree dei diritti di proprietà intellettuale, come per esempio per i marchi registrati Dal 94 in effetti abbiamo un marchio comunitario molto riuscito come iniziativa, sì, con qualche attrito a margine, ma che funziona. Lo stesso vale in minore misura per per i brevetti. Abbiamo un brevetto europeo che non è così riuscito secondo me, è piuttosto un incubo, ma non mi ci soffermo. E poi abbiamo gli altri diritti di proprietà intellettuale in cui non c'è una protezione unitaria. Dovremmo confrontarci col fatto, penso, che i diritti d'autore non hanno questo livello di protezione europeo, e perché appunto è un diritto di proprietà intellettuale differente. I diritti di proprietà intellettuale hanno vissuto qualcosa come 9 tornate di armonizzazione, 9 direttive. E risentono di questa frammentazione residua. Chiamiamolo il principio di esaurimento, come viene detto in Europa. Se si vende sul mercato qualcosa che è coperto da un brevetto o da un marchio registrato, il diritto del titolare viene a un certo punto esaurito e quindi può essere distribuito sul mercato unitario. Per quanto riguarda dei diritti d'autore intesi come diritto di copia, quando si parla anche per esempio di una comunicazione al pubblico, non solo di un libro, il diritto non si esaurisce. L'unico diritto esauribile è appunto il diritto di distribuzione, ma la trasmissione e la diffusione del pubblico non sono mai esauriti, non vanno mai esauriti, quindi nella pratica anche dopo la messa sul mercato di un servizio coperto dal diritto d'autore, questo servizio resta riservato e permane la frammentazione territoriale. Questo è piuttosto un paradosso, perché se andiamo a riflettere sui beni digitali, sono i più facili da trasportare oltre frontiera, proprio perché prendono un formato numerico digitale e possono essere inoltrati attraverso la rete digitale. Un frigorifero o qualunque bene fisico come una bottiglia d'acqua, questi vanno caricati su un camion, hanno bisogno di essere trasportati fisicamente e non possono passare attraverso una rete. Ciò nonostante abbiamo un massimo di frammentazione paradossale, e qui vi faccio 2 esempi. Uno è il caso dei campionati di calcio di Serie A. Dicevo, partite di calcio che quando per esempio un greco residente in Grecia stipula un accordo specifico con l'emittente greca, e quindi questo diritto che ha con l'emittente greca non è trasferibile o trasportabile, per esempio il Regno Unito. E questo è un caso proprio di compartimentazione. Un altro caso sarebbe quello dell'e-learning, l'apprendimento elettronico. Le nostre istituzioni non possono prestare libri in via transfrontaliera, cioè tra un ateneo e l'altro, perché questo ancora non è stato liberalizzato. Questa è una situazione incresciosa, direi io, e quindi come la risolviamo? Abbiamo 2 prospettive per superare questa situazione. Una riguarda il superamento del concetto di territorialità, E qui va fatta qualche osservazione, ma prima di dire qual è l'alternativa vi dico, supraterritorialità significa la seconda prospettiva riguarda un aggiornamento del diritto d'autore. Scordiamoci per un attimo dei 28 Stati membri europei e concentriamoci sul fatto che il diritto d'autore fu creato 3 secoli fa. Gli autori, i creatori, chi erano? Erano professionisti. Che vivevano del loro lavoro intellettuale, scrittori, musicisti, intellettuali. Questo era il loro lavoro principale, la loro carriera in pratica e quindi per loro era indispensabile poter stipulare un patto con le aziende che commercializzavano il loro prodotto presso il pubblico. E da qui nacque l'esigenza del diritto di copia a beneficio di autori e di chi poi creava la copia fisica. Oggi, chi sono i creatori? Ci sono professionisti tra di loro ancora oggi, questo è importante, e questo aspetto va tutelato e promosso, ma oltre ai professionisti abbiamo tantissimi creatori non professionali, risultato della cooperazione tra voi, me, tutti noi. Sul net siamo creatori. Chiunque faccia un lavoro creativo e anche intellettuale e lo condivide sul net lo fa. E qui ho 2 esempi. Abbiamo Wikipedia, per esempio, la condivisione di regali in via reciproca, ma è un software aperto, un modello ibrido, in cui in qualche modo si cede il proprio diritto di proprietà intellettuale, ma questo è un modo intelligente di mettersi sul mercato e di essere pagati per i servizi complementari. Quindi questa nuova creatività non è di vecchio stampo dove un professionista presta servizi per la propria sussistenza, ma per cooperare nel creare un modo per adattare nuovi modelli economici di fare affari. Perché lo dico? Lo dico perché questo è il secondo leitmotiv. Le leggi sui diritti d'autore, no, vogliamo rispettarle. Mi sono visto a Roma con gli accademici in materia di diritto e Davide Sarti disse: la prospettiva è sbagliata, non dovremmo cambiare nulla. Magari ha ragione. La prima alternativa è non cambiare nulla, se poi cambiamo perché siamo interessati a questo livello europeo.
Copyrights, or are we changing because we want to go from the original professional-oriented copyright to one more comprehensive, which also takes into account the interest of Wikipedia and the interest of open source software, all these cooperative models which are based on not on exclusivity but on cooperation over the net. These are 2 separate strands. Before we move to the next slide, let me say that even though I have been, this would be still the previous slide. Can we just go back for a second? Thank you. but I'm taking more time because I was told by the organizers that we have a little bit more time there is one person. How much time do I have?
5 minutes.
Okay. Maybe there will be 7.
10 minutes, all right.
Okay.
Okay.
So this is 10:26. I think that we'll make it in less than 10 minutes. No, I was telling you that I myself have been writing this letter to Oettinger saying, let's go from 28 member states to a European code. So the first perspective finds me as a supporter. But I have some reservation, some objection to this approach. One is that, and Giuseppe has written very well about this, in some cases there is not much pan-European demand because European culture and languages is fragmented. So maybe in soccer you have a unitary demand, but even then advertisers are different, and so it's not so clear that we have a pan-European demand. And the same applies to movies. And when we talk about movies, you think that you think about Netflix these days, and I must also say that I have some misgivings about creating a pan-European level playing field right now. Maybe it would have been a good thing 15 years ago, but now we have American businesses coming over here, and somebody has said that if we create a pan-European playing ground, ultimately we are not helping the European champions, but we are helping the Americans. This is a subject, this is an argument which is open to criticism because which should not look in the face and say this is German, this is American, this is Italian. I think that the question is it contributing to the welfare, not what is the nationality. But still, I wanted to say that even the idea of moving to a post-national pan-European copyright has some kind of objections, but still we explore it, and by the next slide, please. And let me say that there are 3 ways to create a pan-European copyright. And we have already witnessed the satellite cable approach, which was Directive 93/83, which said that if you have a work which is made available by broadcasting and or rebroadcasting through satellite and cable, you just apply the law of the place of injection. So you don't apply 28 laws, but if the injection takes place in UK, it will be British law. If it's in Italy, it will be Italian law, in spite of the fact that the footprint may be 17 countries or 28 countries, whatever. So this would be a way to unify, and we might think that streaming is not very different from this approach, and so we might extend this to streaming. Another way to create a pan-European copyright might be to have a number of ad hoc measures, like having antitrust come into any situation like the Premier League case, in which you have a feeling that the market would be unitary, but there are agreements in restraint of trade. This is what the European Commission is doing. And this is another way to unify, saying that even in the current situation, antitrust may help to bring together the markets. And collective rights management organizations, the way they have been reformed under the last directive, are ideally in a position to obtain a European passport if they comply with the requirements, and if they have a European passport, they can carry with them their own repertoires and the repertoires of other societies on a transporter basis. This is a piecemeal approach, step by step. Then there is the alternative we've been talking about, which is to have a regulation under Article 118 of the Treaty on the Functioning of the European Union. And this would create, like we have a community trademark and a European unitary patent, a single title at the European level. This would seem to be totally compatible with Article 118, but I have even here some doubts which I wanted to discuss with you. This is number E. No, this is still the previous slide. In trademark and in patent, before you get protection, you have to file an application. Copyright is automatic. So this raises the question that if we have a European copyright regulation, we would have that the same creation is triggering, not because there is an application, but automatically, with the creation of the work and the extrinsication, two layers of protection, one national and one European. Now, you tell me what is the problem. One might say, well, if we still have the national layer, isn't that all the restrictions, the old territorial restrictions would still apply for the national legislation and the national copyright title, like somebody saying, yes, I put on the market and my European title was exhausted, but I still have my national right, and so I can prevent. So maybe the idea is that if we adopt a European copyright regulation, we should say that it is like in the United States, they say it's preempting national protection, meaning you cannot have both. Either you have European or you have national. And this is a possibility and might deal with some of the issues which might otherwise arise. But there is a big question. Is this compatible? Isabella Adinolfi was talking about the European Convention of Human Rights before, and the Charter of Fundamental Rights. But is it possible for European lawmakers to say European copyright, the regulation, is preempting national rights? Is this not destroying a national title of protection, which might be against Article 1 of the protocol to the European Convention on Human Rights, and might also be against, I think, Article 345 of the Treaty on the Functioning of the European Union, which says that the European Union is without prejudice to the legal regimes of ownership of member states. So what I'm telling you, I'm in favor of this, but there are some difficulties. That in 2 minutes I will be over.
No problem. Go ahead.
The other perspective is not from national to pan-European. It's about updating on digital. And if the story is about updating, taking into account copyright not only for professionals but also for digital network-driven cooperation, we have to ask a first issue. What is for the European Union to decide? What is within the jurisdiction of the European Union? And what is, on the other hand, Berne, meaning international conventions, Berne, TRIPS, some restrictions which have been accepted internationally and cannot be changed unilaterally by the European Union. My point is that if we want really to deal with the new kind of digital copyright, we should amend Berne Convention rather than European law. Or at least we should adapt European law in view as a first of having this adaptation as a first step towards a wider approach at the international conventional level. Apart from this higher level of changes, what should European law deal with to be, let's say, fit for the digital age? One thing is limitations and exceptions. Isabella Adinolfi was mentioning this. This is really a priority. Limitations and exceptions today are just optional, not mandatory. So this is not protecting anybody. And this is also making it very difficult for businesses to deal at the European level, because they will have 28 different exceptions and limitations, and have to adapt their businesses to local demands. So this is something which has really to be thought through, and this is a way to combine the territorial and the digital aspects of the reform. I will just mention the importance of dealing, and here we have a BEUC person, with the relationship and the relationship between right holders and end users, the public. This has never been the main subject of copyright, but it has become now in the digital age. And let me mention two things which are very important. The user is always subject to unilateral modification on part of the provider of digital goods, because he has to sign terms, has to take them or leave them. But what is unheard of in the past, and it's novel, is that you have need to update, and when there is an update, you have to re-sign something which is different and not, maybe not so favorable as in the past. So we have consumers who are always accepting, being forced into accepting, and have no way out. And this becomes extremely important, and I finish on this, when we think that even what is in the public domain may no longer be in the public domain tomorrow. Think about Google Maps. How much creativity has been based on Google Maps and other public domain items. This is again a subject which Isabella Dinolfi has been touching, saying the public domain must be clarified and transparent. Yes, and I say, not only this, but imagine what happens if at some point Google says, yes, we have not objected to people using Google Maps, but from next year we're going to phase in a transitional phase at the end of which you pay for this. This would be a disaster, and I think that one has to take into account this possibility, making clear rules in this connection, and this would be a different perspective, not national to European, but old-fashioned to digital. Maybe we can combine the two perspectives, and this is the job before us. Thank you.
Thank you, Professor Ricolfi, for the presentation, very good presentation. So I would like to ask you just a question. So about the enforcement, you didn't mention enforcement, but do you think that it should be a public enforcement through, for example, public administration in Europe, something like, for example, Italian AGCOM, Italian Watchdog Communication? So what do you think about not judicial enforcement, but administrative enforcement?
Well, thank you, Fulvio. This is, I would say, a targeted question which Fulvio is asking of me. He knows that I have been fighting against this non-judicial but administrative enforcement of copyright violations. This was last year. I certainly lost the battle, but as a professor, I must say, now I don't know, because I lost a battle. There has been going on for 1 year.
There is a constitutional court now. No, in these weeks in Italy, the constitutional courts, they are reviewing the public enforcement on the Italian watchdog. So you didn't lose.
Well, okay, but in any event, there has been 1 year of experience by this independent authority. This independent authority, AGCOM, is issuing cease and desist orders, and in some cases is shutting down sites, whole sites, because there is a number of specific violations, or it's taking away the ISDN number. So, in my opinion, this was not something which was compatible with the Italian legislative framework. But now we have 1 year of experience. Before saying that it has been bad or a disaster, I should look at the cases, and maybe they were right and maybe I was wrong. I'm saying this because as a professor, you have always to admit that you may have been totally wrong and start to study again. Okay. So I was exactly on your line 1 year ago. I don't know today.
Thanks. So we have a little problem with the presentation for Giulia Reda, so we are jumping to the next speaker, and then is it okay? Is that okay? No. Is that okay? So everything is okay. So so the next speaker is Giulia Reda. Now we have the privilege to have a speaker, Giulia Reda, Vice President of Greens European Free Alliance Group, Pirate Party, Committee on Legal Affairs. On Monday, 19th of January, Reda released the draft report making a series of recommendations for the improvement of EU copyright laws. On 20th of January, the report on the InfoSoc directive was presented to the Legal Affairs Committee of the European Parliament. The final vote is expected to take place in May. So Digital Commissioner Gunther Oettinger promised a reform proposal by September of this year. So Giulia should talk on the new copyright in the public domain, but before I would like to know some information on the reports. Giulia, you became a star or a devil in these months, depending on the point of view. But let me know what is happening now at the European Parliament copyrights. There is an opposition to your reports. By whom? And what are the mainly focus points of your reports? And what will be the timing of the vote? Before your presentation, if you can.
Of course. Thank you very much for the privilege to be here and talk on this very important topic. Regarding the recommendations, my report, it contains quite a few of the ideas that have been brought forward in the presentations we've heard so far. So about the introduction of a European copyright title and about updating the European copyright to the digital age and making it easier to exchange culture across borders. I think on this topic it's very important to see that here we have one of the few areas at the moment where citizens are actively asking for more European solutions. So the European Commission was doing a consultation last year about copyright, where really the overwhelming majority of users, but also a lot of public institutions and a lot of authors and academics were supporting this idea of more harmonization and exploring also the possibility of a European copyright title. Now, having such European solutions in the negotiations, also in the public representatives are less influenced by ideology of their particular party line, but rather also by familiarity with their particular copyright system in their country. And we had a discussion with the Commission yesterday on the digital single market, where they were also saying that there is a certain narcissism of small differences, that people who are familiar with a particular copyright system think, well, if there is harmonization, it would have to look exactly like what they are used to. And this is making negotiations also on the report quite difficult. But I am hopeful that the people who have become part of this debate, for example, by replying to the copyright consultations and who have made very specific demands that they want to exchange more culture across borders, that they want to have clearer rules, because at the moment they cannot really tell the difference of what is legal and what is illegal because of the mere complexity of the system, that the European representatives are really going to hear these voices. And in this vein, I think it's also interesting to note that when I tweeted the live stream for this particular conference today, a lot of people from my home country of Germany sadly reported to me that the stream is not available in their country.
No, it's streaming written in English. We changed the, so this is...
So I think it's quite clear that sometimes the lack of a European solution is standing in the way even of things that are in the interest of everybody, because I don't think anybody here who is participating in this event is opposed to letting as many people as possible see this discussion. So the vote in the Legal Affairs Committee, which is responsible for this report, is going to be on the 16th of April. And I think it's important that there's also a lot of public attention around this vote. And is most likely going to move to the plenary session in May and will be finally voted in the plenary on the 20th of May. Now, I would like to move on to one topic that I think is quite often forgotten in the discussions around copyright, but that is nevertheless very dear to my heart, and therefore I'm quite happy that I've been asked to talk about this topic of the public domain. I've had quite the same experience as Isabella Dinolfi has also reported, that there is a lot of lobby interest in copyright reform and a lot of pressures. I myself have received well over 100 requests from all different kinds of lobby organizations, particularly from collecting societies, from publishers, from internet service providers or other intermediaries, but actually rather few that are directly representing interests of the public, of libraries, or of authors, aside from the collecting societies. So there's quite an imbalance. There are quite a few lobbyists that are pushing for particular special interests, but I'm asking myself who is really pushing for the interests of the public. And the public domain there is an area where the benefit is more or less equally distributed among everybody, because public domain works refer to works that do not require a permission for reuse. So everybody can reuse these works for whatever purposes they see fit. So it's possible to build a business upon works that are in the public domain, for example, because their copyright term has expired, or because they were never protected by copyright or other intellectual property rights in the first place. So it is possible to create an additional economic value from this work, but it is also possible to simply enrich the people's access to education and to culture, and therefore fostering the public domain and building a European copyright that makes it easier for people to use the public domain and to access it is really in the interest of everybody, in the interest of society, but also in the wider interest of the economy. So one thing that is has been recently discovered, and some studies that are looking into the value of the public domain, is that there really is an economic value. So I would just like to point out one recent study that was done with support from the UK Intellectual Property Office that was looking at the value of public domain images that are used in the English language Wikipedia. And what they found was that, first of all, when for people of interest who have a Wikipedia page, when they died a very long time ago, and there are pictures available in the public domain of these people, it is a lot more likely that a site like Wikipedia is going to have a picture of this person in the page, and this is significantly contributing to the number of people who actually access this. So having these kinds of works in such a page increases the understanding, increases the attractiveness of an offer like Wikipedia. And what this study found is that the added value of the public domain images that are being used in the English language Wikipedia actually amounts to 138 million pounds per year. So well over 100 million euro that would have been paid if a project like Wikipedia had to obtain a license for every single a public domain image that they are using. So what you can see there is that if we don't have a public domain, projects like Wikipedia that are in the public interest would not be possible to even start, because the commercial investment that would have to be done to clear the rights for such a large set of images would certainly be a huge obstacle to any commercial business going in this direction. While this particular study is coming from the UK, I was quite happy to note that also there is some heightened interest in this issue of the public domain on the European level. So the Intellectual Property Observatory of the European Union in Alicante is in this year doing a study that is looking at the value of public domain works in films. So quite a lot of films, for example, documentaries, are using stock footage which is not protected by copyright. And this study by the OHIM is looking at the added value that is coming from this public domain work in the European film industry. So I think a lot more of these studies should be conducted to really show the European lawmakers and the public that it is not only socially important to protect this public domain, but there is really also an economic aspect to this, and it is possible for companies to build on this economic value. So what are the problems that persist with using public domain works? One of the problems that we are facing in Europe is that for the institutions that are usually digitizing works that are already in the public domain but that do not exist in a digital form yet, it is quite often relatively difficult to actually find out whether a work has entered the public domain or not. The European Union has recently set a minimum for the length of copyright terms, which is for most works 70 years after the death of the author, but there persist a relatively large number of particular laws in particular countries that set different standards, like, for example, 80 years after the death in Spain, or particular rules. For example, in Romania, for certain works, you have to know the age of the children of the author at the time of their death, so whether they were adults or not. Or in France, the copyright term is longer if the author died for France in the First or Second World War. So if you take the perspective of a library or an archive that wants to make a work available to the public, you actually have to know all this information and have to find out a lot of detailed information about the author to just even answer the question whether or not a work is in the public domain. And this is, of course, creating a lot of bureaucratic overhead and making it quite difficult for these public interest institutions to actually fulfill their mission. So what I am proposing in my report on copyright is that we do need harmonization in this area of copyright terms, and that it should be applied at the lower end of what is possible under international treaties. So the Berne Convention in particular, setting a minimum standard of 50 years after the death of the author for most types of works, and having this harmonized copyright protection at the lower end of the spectrum of what is possible would really increase the public domain and make it easier for the archives and libraries that are digitizing these works to have legal certainty. So why am I favoring this reduction of copyright terms? This is due to the fact that actually authors and rights holders are not profiting from these very long copyright terms in the most cases. For example, a book that has been published is usually available in a bookshop the first year after it has been published. And if a work hasn't made a commercial profit in these very first months or years after the publications, it's very unlikely that it will ever actually make a profit. So if you have something like 50 years after the death of the author, for the vast majority of authors or rights holders, like the heirs of the author, this wouldn't mean that they would actually have less money, because the vast majority of works is actually no longer commercially available after the 50 years of the death. And quite often the rights holder has also ceased to exist. So for example, publishing companies go out of business, heirs may no longer be found, or they may not even be aware that their ancestors have made a work at a particular time in the past. So this is one image that is illustrating this problem, which is referred to as the 20th century black hole. This is showing two different graphs. One is about the works that are available on the European Public Archive, Europeana, which is collecting public domain works on the internet. And the other one is the number of books that are available on Amazon that have been written in a particular year. And what you can see is that around from works that have been created around the turn of the 19th to the 20th century, you actually have a lot more works that are still available, both commercially and non-commercially, than in the time where the copyright protection still applies. So what happens after a work enters the public domain is that it quite often becomes once again available, because, for example, for publishers, it may be profitable to actually put a work back on the market that they couldn't put on the market before, because the rights clearance situation was unclear. It was impossible to reach the right holder, for example. So both commercially and non-commercially, the number of works that are available for people after the copyright term has expired goes up significantly. So I do believe we need to strike a new balance there between the rights of the authors or rights holders to commercialize their work and the public interest. And I think this balance should be struck in a way that when the vast majority of rights holders is no longer commercializing their work anyway, and there is absolutely no damage to the rights holders, then the public interest should prevail. This is just one illustration of the problem of the still persisting vast difference between the different copyright terms in European countries, and is illustrating the problem of a lack of harmonization that we still have. This is a flowchart from the so-called public domain calculator that has been created by the Europeana project, which is showing the decision tree and all the information that you have to collect to determine whether a particular work is in the public domain or not. So clearly it is impossible for a normal person to actually collect this information and to have legal certainty about whether a work is in the public domain or not. And also for institutions who are specialized in this, it is still creating quite a big administrative burden. So one of the other ways that the public domain could be improved, especially in the internet age, and that is also included in my report, is to make it possible for an author to dedicate a work for the public domain. There are certain workarounds to this issue, like, for example, the quite widespread Creative Commons licenses, which reserve some rights to the authors, but explicitly allow certain other uses. But it is usually not possible to actually dedicate a work to the public domain and to allow all kinds of uses without any restrictions. There are quite a number of reasons why an author would want to do this. For example, when they are creating a work whose main purpose is to convey a particular social message. For example, an artist who wants to draw attention to a social problem like poverty may find it more important to have this work as widespread as possible and not pose any restrictions on their reuse than to receive some sort of personal commercial or personal contribution for making this work available. Another possibility could be that an author may want to circumvent particular restrictive contracts. Like, for example, if I'm a music artist and I want to use the YouTube content ID system, which allows me to commercialize or get a part of the advertising revenue from YouTube when people are watching my works. YouTube is forcing artists to make the entirety of their repertoire, of their musical works, available within the new streaming service that Google is creating. So if I, as an artist, for some reason, don't want to commercialize a particular work, but still want to participate in such a program and commercialize part of my work, one possibility would also be to dedicate a particular work that I want to be freely available to the public domain, and then somebody who is coming to me with a contract could no longer claim that this is part of my repertoire. So this could also be an instrument of actually protecting works against restrictive contracts that are imposed on authors. The main criticism that I hear about this proposal of dedication to the public domain is that some people fear that companies that have a better bargaining position when they are making a contract with an author could force the author to dedicate a work into the public domain. But I don't think this is a very likely scenario, because usually a company that wants to exploit a work commercially would much rather have the exclusive right to commercially exploit it, rather than dedicating a work to the public domain and therefore opening it to the competition by all the companies or all the people who want to exploit this work. So from the people who are bringing forward this particular complaint, I'm looking forward to see whether they are going to support my other proposals that go in the area of strengthening authors' contractual positions and making it easier for them, for example, to reuse their own works when a publisher has received an exclusive right and is not using it. So I think that the benefits of having this possibility to dedicate a work to the public domain greatly outweigh the risks, and that it is quite unlikely that this could be used as an instrument to actually force an author to give up rights to a work when they don't want to. Another issue where I think legislative action is dearly needed, 5 minutes, okay, is the digitization of public domain works. Because what does it mean if a work is in the public domain? It means that the copyright that was granted because of the originality of this work has, for example, expired. But a lot of projects that are actually digitizing such old works are claiming, when they are putting the digital works on the internet, that this digital version suddenly has a new copyright that belongs to them. So, for example, some public archives are scanning old pictures or old books and are then saying that the reuse of these digital images is only allowed for non-commercial purposes, or they put a watermark on it saying that this is created by them and that it cannot be reused without permission. I think this really shouldn't be possible, because actually digitizing a work is not a work of art. It doesn't create a new artwork, but it's rather a technological process that may be quite costly, and it may be difficult to do. So, for example, creating a high-quality digital version of a painting is something that requires a lot of money, for example, but nevertheless, this new work doesn't have any originality. It is still the same work. The creative purpose or the creative energy that has been put into it was done by the author, and that author's copyright has expired. So one of the proposals of my report is also to make sure that once a work is in the public domain, it stays in the public domain even when it is digitized. And one other area that doesn't apply to copyright terms and whether copyright has expired is the question of which kinds of works should be protected by copyright in the first place. There are different theories of why we grant copyright. One of the theories is that copyright is supposed to encourage innovation and to give an incentive for artists to create more works, for example, in the form of money or in the form of recognition. Another theory is saying that when somebody is creating a work of art, there's a particular bond between the artist and the artwork, and they should be protected, for example, from certain transformations of the work that are against the will of the author. But neither of these theories actually applies to some of the areas where we have copyright protection now, like, for example, official works that are created by the government. In Germany, we recently had a case where somebody was making a freedom of information request for an internal document, an internal legal document from a German ministry, and this freedom of information request was granted by law, but the ministry was telling this person that he was not allowed to publish this internal document on the internet because it would violate the copyright of the judges or the legal practitioners within the ministry. I think in such a case, it is quite clear that copyright is not encouraging innovation. The government employees who are creating these works are being paid. They have a secure position, and they are creating these works on request if they are asked for their legal opinion. So something like this, I mean, you could discuss whether there's some sort of special bond between the judge writing an opinion, but at the end of the day, this is a functional document that is supposed to give the government information about whether or not to go forward with a particular legal proposal. And this case was particularly interesting because the legal practitioner inside the ministry was actually telling the government that a law they were proposing was most likely going to be unconstitutional, and the government put forward this proposal anyway, and it was in the end defeated by the German Supreme Court. So in this case, it could be argued that copyright was not being used to protect authors, but rather to keep embarrassing information away from the public. And copyright should not be abused in this way. And therefore, I think for official works, like the picture that is being shown here, which has been taken by the American space agency NASA, that are really created by government employees while exercising their official functions, these works should not be protected by copyright. This is already the case in the United States, but in European countries it's usually not. And one proposal that is also quite prominent in Mrs. Adinolfi's opinion is that we are only thinking about the public domain as a negative definition so far. So we have a clear legal definition of copyright, and then the public domain is kind of a fuzzy concept of everything that is not covered by these exclusive rights. But if we really take the public domain seriously and recognize that it has a social and a commercial value, it would be better to actually write a positive definition of what is the public domain into the law. And I'm just giving an example here of one definition of how such a public domain definition could look like. This is once again taken from the CREATE study that I presented at the beginning, that was done with support of the UK Intellectual Property Office, that is saying that public domain works are works whose copyright or other related rights protection has expired. Materials that were never protected by copyright in the first place. One example could be the picture that we see here, which was actually taken by an ape. And regular definitions of copyright think that copyright can only be granted to humans and not to an ape taking a picture of herself. But this is also legally contested, whether this work actually is in the public domain. So this is once again showing that having a legal definition would really be helpful. And then, of course, also included should be works that are not sufficiently original to be a new work of art. So, for example, the digitization of a work in the public domain would also be in the public domain under this definition. And once again, this definition could include works that are voluntarily dedicated to the public domain by their creator. So I hope that these proposals that are really in the public interest and that are not hurting authors and rights holders in any way are being accepted in the European institutions and will be an important part of the upcoming European copyright legislation, because I think they could really have a huge added value socially, educationally, commercially to Europe, and could really make the best use of the rich cultural heritage that we have. Thank you.
Thank you, Giulia, for your presentation. And I remind everyone that every EU citizen has the opportunity to express their thoughts to the Parliament members. And I call on the people who are listening to submit their ideas to the parliamentary before the final vote in May. So now we're speaking about digital levies. The copyright has a very strong impact on the consumers that use technology devices every day because of the system of fair compensation of private copying, which provides that a portion of the sale price of digital devices should go to the author to compensate them for possible reproduction of content covered by copyright. In 2003, Professor Bernd Hugenholtz and Van Geffen of the Institute for Information Law of Amsterdam held a report entitled "The Future of Levies in a Digital Environment." The report showed a large fragmentation of the system of the private copying and the lack of transparency of costs paid by the consumers. Now we invite to have a speech on the impact of the fair compensation on consumers, Mr. Agustin Reina. Agustin works as a legal officer in BEOC, the European Consumers Organization. BEOC represents 40 independent national consumers associations from 31 European countries. Agustin Reina, please.
Thank you very much. Hello, everyone, and thank you very much to Mrs. Adinolfi for the invitation and for the party. For us, it's very important to be able to provide the consumer point of view in the copyright reform, as copyright law often ignores the consumer interest, although that consumers are the one paying for the system. And in this opportunity, I would like to discuss with you the issue of copyright levies, which is an interesting topic, not because it's difficult to criticize the current system, but mainly because it's difficult to get rid of it. So if we go to the first slide, please. So setting the scene, what are we talking about when we refer to levies? First of all, we have to think that it's a compensation scheme. Why is a compensation scheme? Because you pay for levies, you pay for compensation when there is a damage, when there is harm. So it's not a remuneration system. And this has been already confirmed by the ECJ in several cases. But the question is, what is the damage? The damage is linked to the act of private copying, which is an exception, as we know. It's not fully harmonized, it's not mandatory in most member states. And the scope of this exemption varies significantly from country to country. So the private copying, according to the Copyright Directive, which is our starting point, is a reproduction of any means by a natural person and for private use, which could be anything, basically. And actually, have you seen in the member states, the interpretation and implementation is quite different, especially, for example, when it comes to the beneficiaries of this exemption. Then we have the conditions for the application of levies, which are implied in recital 35 of the Copyright Directive, which is the harm resulting from the private copying. It has to be taken into account. It says other form of remuneration. I would rather say the remuneration, meaning the license. And then the application of technical protection measures that can and often impede the act of private copying. And finally, which is very important, is that there is no obligation in the international treaties, international sources, or even in the European sources, for member states to adopt levies. We pass to the next slide, please. So what is the current status? We have 22 member states that have adopted levies, this compensation scheme, but there are divergences at national level in relation to which media or equipment the levies apply. So, for example, black media can be found in the 22 member states. The levies apply to MP3 players in 18 member states, in printers 12. And if we look to more recent hardware, for example, like tablets, there are even few. We have last year a decision from the Conseil d'État in France that say that tablets, they have to pay levies now. Then the economic dimension, I quoted there a figure that is already for some some years ago, which represents a significant part of EU trade. So there are many goods, especially consumer goods, that can be subject to levies. This figure is from 2009, but with the new technologies, we have new type of hardware, so new products that can be subject to levies. At the same time, we have new business model for accessing copyrighted content. So now we see a tendency among consumers to start moving for the traditional tangible, the content that you access by buying a CD or DVDs on tangible media, moving towards online access business models. If you go to the next slide, a little bit the three consumer issues when it comes to levies. First, I will refer to pricing and whether the application of levy could be a case of cross-border discrimination. Then transparency, the visibility of the fee. We heard already that this is a major problem, and it has been included also, for example, in the Vitorino recommendations. And finally, the economic harm of the levies for the consumer. If we go to the first slide, so we have cross-border pricing. So due to the different rates on levies, online traders have to price goods differently. So in some countries, because of levies, some goods will be taxed heavier than in other countries. For example, I give here the case of the iPod Touch, that it's from one country could go for 1.4 euros up to 20 euros in another country. The same happened with the final price of a printer because of the application of levies. So the question is, and whether this situation first could constitute an obstacle to trade and to the free movement of goods, and secondly, whether it can limit consumer choices. And this limitation is given basically because of the place of residence. So then we have a non-discrimination principle in EU law, which is in the services directive, and copyright law is the big exemption to this. So we don't touch copyright law, no, on a basis of discrimination on the basis of nationality of residence. But is this today, and taking into account the state of the technology, an objective justified criteria? I doubt. And then finally, we think that the situation, the idea should be that the levy should apply only once, if at all, and it's when the product is placed on the EU market. And then these goods should be able to circulate freely in the EU. Then, of course, we have problems in relation to the distribution of the levies, but I will refer to it later. Next slide, please. So then the second point, I made a mistake there. So the transparency, so it's the price breakdown. And I took two cases from the same country. In this case was France, after the decision of Conseil d'État to apply levies to tablets. And I have in one product, so both from different manufacturers. So in one product, I got the information about the levies, which is actually quite high. If you think about that, the tax for the waste disposal, for the recycling, is 25 cents, and then for the private copying, 8 euros. And if you think that I bought a tablet, which I use it mainly to have all the draft reports and the reports from the European Parliament, but I'm paying levies. So there is no link about the use that you give to the device. And then we have another cases when there is not information at all. So it's also about this awareness side of the levies, and the consumer have the right to be informed that they are paying for the possibility of making private copies, if that's allowed at all because of the application of technical protection measures. Thank you. So the last case is related to my previous point, is the consumer economic harm. So then you have the application of levies to multifunction devices which are not primarily used for private copying. This is the case of cell phones or tablets, like the case that I explained. Then also the use of these devices or devices that entitle private copying should not trigger necessarily the application of levies, because why should I be paying for levies if I don't have any intention to make private copy beyond of what I am entitled to do with the digital content that I buy, no, and which is controlled under technical protection measures. Thirdly, it's the fact that this content that I purchase, includes already in the price the possibility to make a private copying. If you take, for example, the case of iTunes, that they entitle you to make private copies of the content, it's already priced that possibility. So then why I should be paying twice, for this case? So then it leads us to a consumer harm in relation to the double payment, because you're paying for the content and also for the media. And then finally, so what we think that in this context, levies have to be done. First of all, we need to establish clear criteria for the application of levies. How to define the harm? Of course, if member states have decided to apply levies, then we need a disclosure obligation about the amount of levies and whether you're entitled to make private copies. Thirdly, there shouldn't be compensation in case of minimal harm, which will be the case, for example, of format shifting. We need, in relation to the point that I mentioned earlier, a clearing mechanism for collecting societies for the distribution of the levies. So once you place one good in one country, you pay your levies there, meaning the manufacturer or the person affected to the levies, and then there should be a clear mechanism for the collecting societies to ensure that the authors, right holders, receive the compensation. But we should keep focusing on alternative systems, and the best or the solid way to ensure that consumers, that authors get a fair remuneration is through the licensing, and this we have seen it in the models that have emerged in the last years. And here the important part is the fairness of the contract between the authors and the representatives. And finally, as a long-term objective, is to phase out levies completely, as the technology or hopefully the licensing system will not justify having this compensation scheme. Thank you very much.
Thanks. So now we are reaching the heart of the problem, the exception and limitation to copyright. In general, exception and limitation to copyright are special cases defined by law, where the general principle that the prior authorization of the right holder necessary to make use of a work does not apply. That is in the public interest of maintaining balance between the interests of right holders and those of the content users. Giuseppe Mazziotti is, as of October 2014, professor in intellectual property law at the Trinity College in Dublin, and is currently associate fellow at the Center for European Policy Studies in Brussels. Giuseppe last year made an extensive study on the regulation of copyright with some suggestion. Giuseppe will have a speech on a new legal framework for limitation exception to copyright. But Giuseppe, as they can really change the exception and limitation to copyright, and is it possible to speak of mandatory exception in the Union? So what's the real matter with the exception, and why exceptions are a battleground for the stakeholders?
First of all, let me start by thanking the organizers of this workshop. I'm pleased to be here. I'm pleased to be here with all the colleagues, and also for the EFDD group. I'm pleased that they are here in the European Parliament to let the voice of citizens be heard, especially at a time of political crisis of the main political parties. So I'm happy because this gives us the opportunity to discuss issues that are not easy to discuss. I will reply to your questions, Fulvio, while making my presentation. I will make a very brief summarization of what the Information Society did. A few months ago, after the copyright consultation launched by the European Commission, we gained the awareness that the existing legal framework could have been modified. Until 2 years ago, this would have been absolutely not conceivable, considering the pressure coming from the creative industries on the policymakers here in Europe. After the consultation, and I would say most importantly, many of you will remember the clash between the European Parliament and the European Commission at the time of the discussion of the ACTA treaty. That was the turning point, politically speaking. That was the point when copyright started becoming a mainstream subject, and also people in the street and the media covered the issue entailed by copyright largely. So without the ACTA rejection, without that form of disapproval coming from the European Parliament about the plan of the European Commission, we wouldn't be here talking about copyright. So even though, in my opinion, I say that in the book that both Professor Rigolfi and Fulvio Sarzana mentioned, even though ACTA itself was not worse from a user perspective than the legislation we already have in place, it was a good pretext for the people to start talking about what kind of copyright we want. So the Information Society Directive makes an important thing. I mean, we shouldn't forget that this directive was proposed and developed in the late 90s, so more than 15 years ago. At that time, the internet was in its infancy. Most of the things we are accustomed to these days didn't exist. So from a policy point of view, what the Information Society did was actually restating the logic of copyright in the digital environment, basically adapting the rights, the pre-existing rights of the digital environment, and that was the priority. The priority was there because a new environment was about to be created, and there was the fear that the content would not have been paid or remunerated in any way. This obviously raised the worries of the industry, and I would say also of the individual creators. We should never forget, when we talk about copyright, that we talk about the remuneration of individuals first. Then the fact that copyright has become mostly an economic asset that is used by corporations should not let us forget about the main purpose of copyright. And I was pleased to read in the report by Giulia Reda and in the opinion of Isabella Dinolfi the emphasis that has to be placed to the issue of remuneration of individual creators. We still don't know what the best means to achieve this result are, but we have to make it sure that at the very end copyright should beneficial also, if not mostly, to individual creators. So we can move to the next slide. What we have now, we have a very, very broad conceptualization of online rights. This is the result of the InfoSoc directive. The directive expanded the scope of the rights of reproduction and communication to the public that on the internet apply simultaneously. And this creates obviously problems whenever, because of previous assignments of these rights are not owned by the same copyright holders. And this was both this result achieved by the directive was both due to the fact that at that time Europe wanted to harmonize rights. On the other hand, we shouldn't forget that one of the main goals of the directive was that of implementing the WIPO, the so-called WIPO copyright treaties of 1996, which actually one of the most important point was that copyright should have applied also to on-demand transmissions and point-to-point transmissions, because that was the key, from a technical point of view, the key novelty, the key factor of internet communications. We can move to the next slide. When it comes to exception, obviously, if you expand so much the rights and you want the copyright system to, you want to keep the balance of the copyright system in order to avoid that all the stuff that is produced and is made available online gets, restricted unless you have a copyright related permission, you have to reinforce exceptions. Obviously, it also intuitively, it's as a matter of intuition. If you broaden so much the rights and you want to keep the system balanced, you have to provide exceptions. And exceptions are important because on one hand, they protect constitutional values. Freedom of expression, freedom of communication. So the idea behind the exception is that of exempting socially valuable uses from the copyright scope. That's the theoretical reconstruction of what exceptions are about. But as soon as copyright started targeting information goods, and this started with software, in Europe we have also an important regulation of databases, exceptions have become an important tool also to inject competition into the system and to make it sure that the technological advancement is not stopped because of the rights that are the exclusive rights that are conferred into a software or into a database. If you think of, for instance, of the pro-interoperability exception in the software directive that allows to engage in act of reverse engineering of a computer program in order to produce a piece of software that is supposed to be interoperable with a copyright protected software, you understand that exceptions also have a pro-competition and pro-technological innovation function. Very briefly, why is the, to reply to Fulvio, one of Fulvio's questions, why the field of copyright exceptions in the Information Society Directive of 2001 is so problematic? On one hand, the problem stems from the fact that the exception provides a sort of catalog of exceptions, none of which is mandatory, apart from an exception which is designed to let communications among digital networks be made legitimately, but it's not coincidental the fact that the only mandatory exception that we have under the Information Society Directive is not under Article 5. It's under Article 5.1, but it to a certain extent kept separate from the catalog, what I call the catalog. So these exceptions are not made mandatory. So there is no harmonization when it comes to the various categories of exceptions that are listed. At the same time, these categories are constitute an exhaustive series of exceptions. And if you look at them, if you also look at the preparatory work for the directive and also at how the Commission actually tried to understand what exceptions would have been accepted politically, the exceptions for which there would have been political consensus, you understand that there was a clear compromise with the member states. And so what you find in the exception categories, you have a sort of compromise of what the civil and common law traditions with regard to exceptions are about. An important point that the Information Society Directive makes with regard to exceptions is the implementation into the law of the European Union of the so-called three-step test. This is an important point. Even though the function of this test under EU law is not clear yet, the test basically, for you to understand, makes it sure that exceptions are not defined and implemented in an excessively broad way, so that the interest, also the commercial interest of the copyright holders is impacted is affected, so in a negative way. So what the three-step test says is that if member states want to implement one of the exceptions taken from the catalog that is provided under Article 5, they have to make it sure. And this is something that also courts should make it sure. Otherwise, the test which comes from the Berne Convention would not make much sense, in my view. They have to make it sure that those three requirements are respected, and the exception doesn't end up affecting the business of the copyright holder. Obviously, the three-step test speaks about unreasonable prejudice. Every single exception is supposed to make a sort of prejudice. So the limitation itself is designed to deprive the copyright holder of one possible form of exploitation, and this is supposed to be done in the public interest. So very briefly, at the time of the adoption of the Information Society Directive, the European Commission, so the policy maker of the European Union, had several examples that could have been followed in the directive. So we have the exceptions in continental Europe, in the French system, in the systems of continental Europe that follow more or less this French example, in which exceptions are shaped very narrowly. They cannot be applied by analogy. They are perceived as an area of copyright that is not so important because the priority of the copyright system is that of remunerating authors and also recognizing moral rights to authors, the right to the paternity, the right to the integrity of the work. This is the French model. In the UK and in Ireland, the system is different. It's a sort of ideal bridge between continental Europe and the US. We have still statutory provisions which list a number of purposes that could be achieved by non-authorized users of copyright materials. And given the importance of these purposes, certain users of copyright works cannot be licensed by the copyright owners because they are outside the scope of copyright. Research and private study, reporting current events for the purpose of preserving freedom of expression, information, freedom of the media, and for instance the purpose of criticism and or review. All these exceptions that target certain purposes have been widely interpreted by courts in the logic of common law, and they have become extremely important assets for certain industries to work properly. We shouldn't forget that, especially in the digital environment, copyright is the main asset of creative industry, and your exceptions are vital for the viability of other industries. Last but not least, and I'm not going to talk much about this, we have in the US, in this ideal panorama of exceptions in the Western world, in which the exceptions are not shaped narrowly. There's a doctrine, the doctrine of fair use, which is supposed to give courts discretion about the evaluation of the purposes and the effects on the market for the copyright work of a certain use. So we go from continental Europe, where exceptions are very narrowly defined and very specifically defined, to a broad concept, which is that of fair use. So where is the problem? Fulvio asked me, where is the problem with exceptions? The problem is given by the lack of harmonization. On one hand, the Information Society Directive made it impossible for member states to add new exceptions to the existing ones, the ones listed in the directive. If you read Article 5 of the Information Society Directive, if you read the wording of the exceptions, you clearly see that most of the exceptions were conceived as non-applicable explicitly to the digital environment. In the opinion of Isabella Adinolfi, there is a particular emphasis placed on libraries' educational uses. If you look at the exceptions concerning these socially valuable, important uses made by libraries, made by research institutions, you see that the opportunities of the digital environment are not developed. For instance, there was a recent case of the Court of Justice concerning the digitization of a book made by a German university library, and the fact that the publisher of this book objected to the digitization, saying, "But come on, I want to sell you a license for that. I have this kind of permission format for you." But the license had not been concluded. So the case ended up being settled by the Court of Justice, that clearly said that it should not be up to the copyright holder to decide by a contractual means whether or not an exception should be available, should be made available effectively. Because if, and this is something that I will mention at the very end of the presentation, if exceptions could be stifled by contracts and digital rights management systems, the public interest that is behind each exception, so the socially valuable use that the exception intends to protect, would be stifled, would be frustrated. And this is something that should not happen in a balanced system. So there are several uses that are valuable that were not taken into consideration because simply they were technologically non-existing at the time of the adoption of the directive. I make a couple of examples here in this slide. One is online educational uses like the massive online open courses that now are developed by several universities on an eminently translational basis in order to popularize certain subjects. And in these slides, in these materials, in these videos that are made available for non-commercial purposes, universities or educators have to make use to pre-existing materials. In doing so, they reach a pan-European audience. The risk is that in every single country you have a different treatment for that exception. So these activities might be stifled, might be discouraged by the fact that the exceptions, unlike the rights granted by copyright, are not harmonized. And Professor Ricolfi and also Fulvio mentioned the issue of Wikipedia. Obviously, we have to accommodate uses that do not look like the traditional copyright-related uses when it comes to user-generated content. I would say when it comes to activities that are based on the idea of solidarity rather than on gainful purposes. So we have the issue of raised recently by Wikipedia with regard to freedom of panorama. So all the pictures that you might take while traveling, while being in cities, and from a public space, you might end up take a picture of a building or a sculpture which is still under copyright, and you, according to the legislation of a few countries, if you don't have in that country the freedom of panorama exception, which is embodied in the copyright directive but is not mandatory, that use in that particular country might be deemed to be copyright infringing. So that Wikipedia has to remove the content because otherwise the content would be copyright infringing. So just to going towards the conclusion, we have an increasingly important role of the Court of Justice in the field of exceptions. The Court of Justice, in my view, is doing more than legislative interpretation, is actually achieving harmonization of exceptions, at least as far as the meaning of certain exceptions are concerned. We can move to the next slide. My proposal, which is also the proposal I made in the book that was mentioned several times this morning, and I think it's very reasonable, there should be a ranking of exceptions. The exceptions, as I said a few minutes ago, reflect socially valuable uses, constitutional values, and it's no longer tolerable that in a legal system like that of the EU, where as of the adoption of the Treaty of Lisbon, we have a direct applicability of the Charter of Fundamental Rights, it's no longer tolerable that certain uses that are so vital for the citizens, for the users, also for certain industries, are not protected. Rights should be protected, exceptions should be protected in order to make sure that the copyright system preserves or regains its original balance. So the idea is that certain exceptions should be made mandatory, if not all. Okay? And this is something that the Court of Justice is increasingly saying. Obviously, the Court of Justice doesn't have legislative power. The Court of Justice cannot say that exceptions should be made mandatory because the wording of the Information Society Directive is, is clear. But whenever the court was asked to review the substance and the meaning of exceptions, it happened also recently with regard to parody, but it happened before with regard to the levies and to the in the Padawan decision. Exceptions should not be interpreted and implemented in a non-harmonized manner. If you read the preamble of the Information Society Directive, you will see that exceptions, there is a sort of contradiction between the preamble and the main part, because exceptions, according to the preamble, should have been harmonized from the very beginning. At least the one having a clear cross-border impact. And now there is the issue of technology-enabled uses. We should no longer think of exceptions as something which is beneficial to you. It would be naive. Behind exceptions, there are also gigantic companies, the internet companies. So it's important to regulate them well, not only to avoid obstructing the business of these big companies, but also to make it sure that there are certain users that should be remunerated, certain users that should remain free for the digital single market, for the internet-based services to continue to grow. I will briefly mention here text and data mining, user-generated content, levies were already mentioned, the issue concerning digital libraries, in particular the opportunities of e-lending, and all the educational uses that rely widely on use of portions of copyright materials, and so on exceptions. We should be very careful, and we should make it sure, as I say in the last slide, and I conclude here, that exceptions become mandatory, and in the same way as in the software directive, exceptions should be protected by contractual override, so that at least certain values that are incorporated into these exemptions from the copyright scope cannot be stifled by the industry. Thank you very much.
Thank you, Giuseppe. So now we will speak about a very highly debated topic, is the intellectual property enforcement in the digital age, the liability of the internet service provider. It's now my pleasure to introduce Innocenzo Genna. Innocenzo is an independent public affairs consultant in telecoms and internet regulation. He's currently also council officer of EuroISPA, the European ISP Association, and is director of AP, the Italian ISP Association. As you know, the issue of liability of internet service provider enforcement topics is treated by Directive IPRED and not InfoSoc. As well as the InfoSoc directive, also IPRED directive is subject to reviewing by the European Parliament. The draft report towards a renewed consensus on the enforcement of intellectual property rights and EU action plan presented by member of the European Parliament, Pavel Svoboda, was discussed last week at the EU Parliament Culture Commission. According to the Human Rights Association, more worryingly, the report appears to call for the implementation of certain enforcement measures which do not require public or judicial supervision. Michel Raymond, rapporteur for Cal Commission, withdrew his signature following the presentation of very aggressive amendments by other groups. Innocenzo, do you think that it's possible to find a balance between the rights of authors and the free circulation of content without forcing service providers to be cops, policemen?
Thanks everybody. Thanks Isabella. Thanks Fulvio to have the privilege to be here. Of course, my immediate reply to your question is, of course, it is possible, but you must understand how digitalization works, because frequently stakeholders, politicians, and other actors of this debate, they don't understand how the digitalization has changed the rules of the game. And correctly, Agustin said that sometimes he believes that the right holder, they don't understand, that they don't care about their customers. And this was a big mistake, because the digitalizations changed completely the way customers are approaching the market, because they're not just passive buyer or something. They are creators, they are active. If they don't like something, they find ways to find something else. And especially they can even support the emergence of new business model. This is something that the telco industry understood at a certain time, because we also had the same kind of passive customers for some time, and then everything changed, because customers found that it was possible to phone without spending money. So, and telcos lost a lot of revenue on voice, but we didn't make too much complaint. We understood that the market was changing. And digitalization, for this reason, also changed the way revenues works. Again, you can't believe to sit always on the same amount of revenue when the digitalization is there, because there your treasury can be burned very, very easily. Again, the telcos industry knows very well. 20 years ago, most of our operators were just making money, just selling voice and fax, and they said that was enough. Now, if you look at the same operators now, they are selling broadband and other kind of services. They're maintaining the same level of revenue, sometimes even declining, but the business model has completely changed. They exist because they understood the role of the games. This is something that sometimes I believe is not very clear when talking with the copyright experts, because some of them, they believe that they can continue to carry on the same reasoning, the same tactic, the same business model in a world which has completely changed. This said, I'm a bit anxious about my slides, because I wrote them last night between 2 and 3 o'clock. So I hope that I think we should go okay. Yes, I completely agree. So for that. So don't forget, when we talk about ISP, so which are basically a network provider and hosting provider, we are not just dealing with the copyright. The digital infrastructure serve for everything. So copyright is a part of the traffic which is relevant for. Most of the traffic is made for any kind of services. I just wanted to stress this because quite frequently ISPs have been accused to make money with thanks to copyright infringements. This is absolutely not true, because when there is an infringement of copyright, ISPs is not making any money of that. And in most of the cases, it may be losing money, because when you have massive infringers, so people are downloading massively, the ISP doesn't make any money of it. Losing money because the retail tariffs are made on the basis of flat rate. So a subscriber pays 30, 40 euros, I don't know what, and then he can download how much they can. So if somebody is heavily making piracy, that will create a cost on the ISPs because on a flat rate, the ISPs will not be able to recover the cost of the bandwidth which is being consumed. So piracy is maybe a problem also for ISPs, and that when there are those kind of abnormal consumption of bandwidth, of course the ISP sometimes they can decide to limit the consumption, but not because somebody is making piracy, because we can't go to our customers, interfere and analyze what they are doing with their internet subscription. We can just eventually remark that there is an abnormal usage of bandwidth, but nothing more. And considering that there is so much variety of different services and interests which are running through our platforms, the fact that there are some conflict is perfectly normal, is something which we cannot avoid, but as Fulvio said, is not for the ISPs to start to judge, to become the gatekeeper, the policeman, to decide who can continue to run, who will not, because ISPs cannot analyze or filter the traffic of internet users because there are data protection rules, and we cannot monitor the traffic. If we do like this, we would be infringing the rights of the users. So there must be somebody else who decide whether there is an infringing activity and must order the ISPs eventually to take some initiative. This works, of course, perfectly for access providers, which are just running pipelines, and also for hosting providers that, they may be requested to remove some content when they have knowledge that something is illicit on their platform. But apart from that, they need the consent of the end user if they want to make any other actions. So the exception of these principles are strictly imposed by law, and it is not something that ISPs can decide by themselves. I needed a slide on digital infrastructure. Okay. Before going, until now I've been talking generally about what the ISPs can do with regard to internet traffic. I was not specific on copyright, so we've been talking generally. There is another general preliminary remark I would like to do, is about a fundamental provision which is in the European framework, which applies to any kind of internet traffic, not only to copyright. And this provision is fundamental, but for some reason is frequently neglected, forgotten. Is Article 13A of the Framework Directive, so the Directive 21 of 2002 regarding electronic communication networks. And these provisions set forth the rules whereby measures can be addressed with regard to internet access and services over the internet. This provision is fundamental because make clear that any measures of this kind must respect the fundamental rights and freedom of people. When interfering with individual rights, must be appropriate, proportionate, and necessary within a democratic society. And then there is a list of conditions which are quite strict. And this is something which applies to any kind of interference over the internet, including copyright enforcement measure. And I think that politicians, stakeholders, and operators should take into account of this, because if you don't do it, then you may lose a case in front of a court. And this is one of the reasons why I see that there is a case in Italy in front of the Constitutional Court regarding the Agicom regulation copyright, because they probably underestimate some conditions that they have to respect if they want to interfere with the activity of activity of end user in the internet. Next. Okay. So this slide we go a bit more specifically to copyright. So copyright is a fundamental right. I think is nothing to say about this, but is a fundamental right like other rights which are protected in a democratic society. Is not for the ISPs to strike the right balance between those kind of rights in general, but also in practice. In general, it's for the legislator to decide eventually which right must prevail. In practice, is for the judges to decide what will be right and wrong. For the reason I told you, because you have to consider a lot of conditions, you must be impartial, and only a judge can take such a decision. The Court of Justice of the European Community was very clear in this, in the cases Saban and UPC, and while considering cases of filtering, web blocking, and in those cases, then he reminded that the copyright must respect the freedom of business, privacy, and freedom of information. Why? Because when you ask intermediary to act on your behalf in order to block or to remove content and so on, you are anyway asking another operator, another undertakings, to make an activity on your behalf. And this is not always right, because you can't ask another industry to make the work for another one. So this is what the Court of Justice said, the respect of the freedom of business. You have to respect the right of end users, privacy, and the freedom of information, because any time you remove or you block content, you are interfering on information amongst individuals. And this is something that may not be justified. So the court was quite clear. Copyright is a fundamental right, but you have to consider there are also fundamental rights which must be respected. And it's not for the ISPs to strike this balance. There only a judge can, in concrete case, decide which right must prevail, and with an injunction can ask eventually the ISP to take action. Then, deriving from this principle, I would explain why there is a misunderstanding about self-regulation in enforcement copyright measures. Self-regulatory measure can't substitute enforcement because, for the reason I told you before, there are too many conditions and fundamental rights and interests which must be respected when dealing with intervention in the internet regarding individual interest, that the risk to make something wrong is too high. So it's not something that can be agreed between private parties, between NISPs, between a right holder. You can't make a self-regulatory initiative which may affect the right of end users. Nobody would take this risk. Must say that before 2001, so before the 2011, before the Court of Justice made the case Sabam, there was a huge pressure by stakeholders over ISPs to say, we want to negotiate with you the way we will stop infringement in the internet. And our industry normally resisted, not because they didn't want to cooperate, but because when we are talking about measures which may affect the interest of end user, fundamental interest, we can make a private negotiation. It is something which is out of our control. It is something that only a judge can decide. And I'm quite happy that with the Sabam case, the court approved this point of view, and also induced the commissioner also to better understand that enforcement is not a matter of self-regulation. Enforcement is a matter of law and judges and jurisdictions. Self-regulation may happen in other areas. For instance, increasing awareness among stakeholders, trying to develop new business model. That's an area where self-regulation is maybe much better than any legislative action. But with regard to enforcement, enforcement is a matter of law. So finally, so what we have now for in the enforcement for copyright, we have a directive, the 2004 number 38, which is the enforcement directive. There are some enforcement measures also in the copyright InfoSoc directive. Such a directive has been implemented for more than 10 years. I think that the implementation is quite successful. I think our industry has been experiencing a lot of thousands of injunctions different ways. Sometimes we have been contesting them, but in any case, what really matters is that there is a judge decided about an injunction in a clear framework. In Italy is the country, for instance, of website blocking, sometimes even too much. This is one of the reasons why I never understood why we had this initiative of Agicom in the matter of copyright, because if you want to target really copyright infringement, probably Italy will be one of the latest countries where to intervene, because anytime you see judges blocking on website for anything, sometimes there was a special case of Moncler. You know Moncler, no? And it was a judge who, just upon the request of Moncler, of course, they blocked 500 domain name and website because there was the Moncler there. It was just made, they didn't even consider if the claim was really deserved, but they did it. And then in the blocked website, you had even the club of the fan of Moncler, no? The people supporting Moncler, they had a website, we love Moncler. That was blocked because of piracy reason, they said. And of course, then later this decree was annulled in the appeal, but this gives you an example that there is no problem in enforcement measure for copyright. Sometimes they even go beyond of what should be reasonably conceivable. This is why I don't understand why there is so much pressure about revising enforcement rules. I can understand that tactically is a way just to distract the attention of the legislator from an area to another. Say, we want to make enforcement even more stronger. I understand that tactically may work, but me, regarding how this market works, I don't see needs for more enforcement, which is necessary and must be done. What I really need is to intervene more in the causes, in the reasons why people sometimes they behave illicitly or behave in a way which is illicit and they believe to be legal. Of course, there is also this problem. The problem is that the framework must evolve and become more adapted to the digital economy, and we should try to make more efforts in making more legal business to emerge, more legal content to be there, and help also new providers, a new service provider to get access to content and being able to provide at best what the consumer wants. because at the end we are here to serve our consumer, and if the consumers are happy, we will our business will continue to flourish. So I believe that the most important thing which has to be done is to reform the copyright, understand that this reform will be disruptive. You may have a loser and winner, but there are a lot of operators, in my experience, that when they understand and they be losing, they change the business model and they can become winner. And in our industry, you have been operators who have been changing completely their business model, and they're still there, and other that disappeared in 5, 6 years. That's something you know very well. I think that everybody must understand that if you want to sit on the winning side of history, you must understand, in this case, how digitalization works and adapt yourself.
Thank you. Thank you, Innocenzo. So you remember the Moncler cases. I was the lawyer of the internet service provider, and then the appeal court said the order was disproportionate and cancelled the order. But every day in Italy happens something like this with this internet service provider, and now we have not only the judge, but an administrative body, the communication watchdog, it is called AGCOM, that gave orders in 2 or 3 days without any kind of defense or any kind of due process of law. So it's a really problem to balance the rights holders and protecting fundamental rights in the information society. And I think that the legislator, European legislator, should be how do you say, balance, and because it's a very good topic, a highly debated topic, but the balance is the only way to do it. So the next speakers is Eleonora Rosati, last but not least, of course. Eleonora Rosati teaches intellectual property law at the University of Southampton. She's deputy editor of the Journal of Intellectual Property Law and Practice at Oxford. She was a postdoctoral legal research associate at the University of Cambridge. She has written in the field of intellectual property and is a regular contributor to EPCAT blogs, a very well-known blogs on copyright. Eleonora, in November 2011, Bernd Hugenholtz and Martin Senfleben of Amsterdam published a study that explored existing flexibility within the European copyright regime that could be used to introduce the concept of fair use in Europe. This study follows on the heels of the Airgraves review, which examined the possibility of introducing a fair use exception in the UK. Eleonora, the simple word fair use generates in many stakeholders an immediate reaction. No, you cannot. But why? Eleonora, can you explain to us if there is the possibility of introducing in the European rules an open norm modeled on the fair use?
Thanks so much, Fulvio, for your presentation, and thanks so much for inviting me today. It is a great honor for me to be here, and I would like to thank also my fellow panelists for their very thoughtful presentations, from which I've learned a lot. So, to answer your question, really the topic of my presentation is whether it is possible to introduce an open norm in the current wording of Article 5 of the Information Society Directive, as has been most recently advocated by Giulia Reda in her draft report. To address this question, I would like to address the following points. The first one is to touch briefly upon Article 5 of the Information Society Directive. A little more slowly for me. Sorry. I will speak slower. This is a problem of mine. I apologize. All right. So I would like to start by recalling briefly Article 5 of the Information Society Directive, and not to go too much into detail because Giuseppe has already addressed it at some length. But I would like to recall the structure of this provision, and in particular the aims that the European Union wished to achieve by introducing this provision into the main EU Copyright Directive. Then I would like to go into recent decisions of the Court of Justice of the European Union, which have interpreted Article 5 and in my opinion, contrary to the 2011 paper by Hugenholz and Senftleben, the Court of Justice has interpreted Article 5 as being much less flexible than the way they have suggested. And in particular, this recent case law, I think that shows pretty well that despite the attempted harmonization of exceptions and limitations at the EU level, this is not what has happened in practice, because member states have adopted very diverging exceptions, and therefore the harmonizing goal of the Information Society Directive perhaps has failed in respect of exceptions and limitations. Then I would like to touch upon the case of national implementations, and in particular the case of the United Kingdom, which shows pretty well how member states have struggled accommodating Article 5 exceptions into their own national laws, and how lengthy the process of updating the resulting exceptions and limitations might be. Let's just think that the United Kingdom started a discussion on updating its system of exceptions and limitations back in 2006, and the outcome of this reflection was an overhaul of existing exceptions and limitations, which were broadened in scope, new exceptions were introduced, and this is a process that took place just at the end of 2014, so quite a long period of time. And then the final part of my presentation would touch upon Article 5, and in particular whether it is possible to reform it by means of introducing an open norm, and whether there are any legal obstacles in this respect. And I think that there are not, or if there are legal obstacles, they are not significant. And in particular, I believe that the real question that should be addressed is whether it is desirable for the EU as such to introduce an open norm. So let's start with the first topic that I would like to address, that is that of Article 5. As Giuseppe mentioned at some length, this provision has a list which has been called a shopping list by Hugenholz and Senftleben of optional exceptions and limitations. They are all optional but one, the exception for temporary copies. And then member states are free to decide in respect of what rights such exceptions should apply, whether just the right of reproduction or also the right of communication making available to the public, and where a member state has decided to adopt an exception to the right of reproduction might also decide to extend it to the right of distribution. The umbrella clause in this respect is the three-step test in Article 5, paragraph 5, which is still unclear to whom it is addressed. Possibly the three-step test is addressed at national legislators and courts alike, but it seems that also the Court of Justice has engaged in a direct interpretation of the three-step test. The latest instance being the decision in Asi-Adam, in which the CJU quashed the Dutch exception on private copying. Overall, why did the EU decide to harmonize exceptions and limitations? It did so on internal market building concerns, and decided to have such a lengthy list to take into account the different legal traditions across the European Union. However, despite the recognition that it is necessary to take account of these different traditions, and Article 5, paragraph 3, letter O includes a grandfather clause which allows member states to retain pre-existing exceptions if certain circumstances are met. The same recital also mandates upon member states to achieve a coherent application of exceptions and limitations. And whether this is what has happened is questionable. Why? Because as Hugenholtz and Senftleben in their 2011 paper acknowledged, the wording of Article 5 is not as precise as it might have been should the EU wish to actually achieve an harmonization of exceptions and limitations. In fact, they speak of Article 5 exceptions as categorically worded prototypes, which allowed member states to have this apparent degree of flexibility in deciding how to design their national exceptions and limitations. And in practice, this is what has happened. Let's take the example, for instance, of the private copying exception, which has been intended in fairly diverging ways across the territory of the European Union. We went from the very broad exception under Dutch law, which allowed reproductions from both lawful and unlawful sources, to having a new exception under UK copyright starting in 2014, which does not come with a levy system, and this is why the exception is currently under a judicial review, possibly on lack of compatibility with EU law. But at the same time, is also an exception which is fairly narrow in scope, in that certainly does not allow you and your friend to watch the copy that you've made of a film together, because the exception is limited to just personal uses. So if you want to copy a film that you own, you can do so, but you must then watch it alone, because otherwise you will fall outside the scope of the exception. Similarly, this has happened also in respect of the parody exception, because the UK, which is notorious for its sense of humor, but until last year didn't have an exception for parody, and decided to implement it by framing it within fair dealing, so possibly making the exception even narrower than what is allowed under the Information Society Directive. And something similar is what France did by requiring parody to comply with the loi de genre. Another example, the disability exception. If you look at Article 5, you will see that member states can introduce an exception to help disabled people to enjoy works. However, the directive does not say what disabilities the exceptions should be limited to. And there are certain member states that have limited the scope of the exception to certain specific disabilities, such as visually impaired people. So one might wonder whether it was possible for member states like the United Kingdom to have an exception for blind people only, and not also an exception, as it is now following the post-Hargraves implementation, that encompasses all types of disability. And these diverging national implementations have occurred on belief that the wording of Article 5 was not that precise, but despite what is clearly stated in Recital 32, which I have already mentioned, and Recital 31, which makes it clear that existing differences in the exceptions and limitations have direct negative effects on the functioning of the internal market. And despite this opinion about the interpretation of Article 5, in recent times the Court of Justice of the European Union has somehow changed its approach to the interpretation of this provision. In particular, in the recent past, especially Advocate General Tristesnack and Sharpston held the view, like Hugenholtz and Senftleben, that Article 5 is composed of categorically worded prototypes, and that member states enjoy a significant degree of flexibility. But in recent cases, and in particular Padoan, Asi Adam, the Dekmin case on parody, etc., the Court of Justice seems to have taken a completely different approach, as also Giuseppe mentioned, and in particular it has interpreted Article 5 as being much less flexible than what has been believed so far. And possibly this might be due to the fact that the Court of Justice has become fairly active, at least since 2009, in interpreting the body of EU copyright, and is pushing towards a kind of full harmonization of copyright even outside legislative intervention. So it might be that this inflexible interpretation of Article 5 can be considered as part of the agenda of the Court of Justice in having a more coherent application and understanding of copyright among the member states of the European Union. All these pedantic overview of the Court of Justice case law to tell you what? That the objective of harmonizing exceptions and limitations in Article 5 has not been really achieved. The idea of having a closed list as being something helpful for member states to rely upon has proved to being unable to achieve the scope that it was meant to achieve. So this with regard to the closed list and the fact that no harmonization has occurred. Now let's take the case of national implementations. I mentioned the case of the United Kingdom because it is a fairly interesting member state. When the UK implemented the InfoSoc directive into its own national law, decided not to take full advantage of the possibility afforded under Article 5. In particular, there were notable omissions. The UK decided not to have an exception for private copying and decided, for instance, not to have an exception for parody, caricature, and pastiche. Criticism about the excessively narrow scope of UK exceptions started in mid-2000s. The first review, the Gowers Review, advocated for the introduction of new exceptions into UK copyright law, but did not receive any real follow-up, while the Hargreaves Review of 2011 was more successful in this respect. And now the UK government has endorsed most of the recommendations included in the Hargreaves Review, and last year undertook a revision of its system of copyright exceptions and limitations. But again, for instance, with regard to private copying and parody, decided to have its own understanding of how the exceptions should look like, and the result is that now the exception for private copying is subject to judicial review. It is not clear whether it is compatible with EU law, and the exception for parody, being framed within fair dealing, is possibly narrower than what is allowed under UK law. And again, the example of the UK, to me, suggests that it is not an easy process to rely on a closed list of exceptions and limitations, and there are also transaction costs associated with updating one's own system of exceptions and limitations. A problem that possibly will be less strong should the EU have an open norm that member states could decide to have into their own national systems. And indeed, the possibility of reforming Article 5 is currently being discussed. Julia Reda, in her draft report, advocated the introduction of an open norm, and this is something that I think echoes the proposal advanced previously by the academics reunited in the WITEM group, which Professor Ricolfi mentioned earlier this morning. And the WITEM group produced a European copyright code, which could serve as a model for a new copyright title, and among other things, they advocated the introduction of an open norm in Article 5, possibly Article 5 of the Information Society Directive, which would allow member states to consider lawful uses that are not subject to specific exceptions and limitations, but that nonetheless can be compared to uses already subject to specific exceptions and limitations, provided that such uses comply with the three-step test, meaning that they are limited to certain special cases, which do not conflict with a normal exploitation of the work, and do not unreasonably prejudice the legitimate interest of right holders. Although in the WITEM code, the term right holders is replaced with that of third parties, possibly suggesting something broader than the three-step test. What does all this mean? That possibly the EU is trying to inject some flexibility into its own system by taking inspiration from the US fair use model. Why is that? Because if you ask about certain uses that are considered okay in the US, the answer will not be the same in the EU at all. Let's take, for instance, the case of user-generated content, which was mentioned this morning, which possibly will not be covered by any specific exception under EU law. Another case is, for instance, text and data mining, which the UK has recognized as falling under the research exception, but in any case, it is in much more limited scope than what is allowed under US fair use. So let's now consider what EU-style fair use could look like. Certainly, US fair use has been praised and has been taken as an example of a very flexible way to allow technology to evolve without the need for legislative update. One of the criticism that have been expressed against fair use is that perhaps it is not compatible with the three-step test in the international treaty system, and notably with the Berne Convention three-step test or the WIPO Copyright Treaty three-step test. There has been, so far as I'm aware, no conclusive determination of whether US fair use is compatible with the three-step test, but there has been an interpretation by a WTO panel regarding a three-step test in the TRIPS agreement, in which this 2000 decision suggested that US fair use is not incompatible with the three-step test. So US fair use is okay, and in the EU example would be even more okay because the language of the open norm would replicate the language of the three-step test itself. So there will be no criticism as those that can be expressed against the US fair use. Again, an open norm has always been said to favor flexibility at the expenses of legal certainty, in the sense that if you know what you cannot do, you are able to predict better about the actual lawfulness of uses of a work, while instead, if you rely on an open norm, there is less certainty about whether that particular use of a work can be considered fair or not. And again, this is a criticism that has been advanced against the introduction of US-style fair use in countries like Australia, where last year there was a debate in this sense, and it is an argument that can be used against introducing an open norm also in EU copyright. However, it is interesting to refer to a study by Barton Beebe in the United States, who showed that when you take fair use cases and you look at the decisions at first instance, the number of overruling at the Court of Appeal level is not higher than in other areas of the law. This suggesting what? That fair use is not necessarily more unpredictable than other legal doctrines, at least as far as the US is concerned. So this to suggest that the legal obstacles that are currently being presented against the introduction of an open norm also in EU copyright have been probably exaggerated, because there might be no issue of compatibility or lack thereof with the international treaty system, and the issue of lack of legal certainty might not actually find real evidence in application by courts. So the core of the question, I believe, is not whether it is possible or not to introduce an open norm, but whether instead it is something that the EU should do. And the fact that Article 5 has failed to harmonize the system of exceptions and limitations, to me might be considered an argument as suggesting that introducing an open norm might actually favor a more harmonious interpretation of exceptions and limitations, and in particular with the advantage of having a flexibility into the system which is currently lacking. Let's take the case of the United Kingdom, which took many years, at least 8 years, to update its system of exceptions and limitations. If the UK had been able to rely on an open norm modeled on the three-step test, possibly the need of discussing the introduction of a parody exception or a private copying exception would have been much less serious business than what has been instead in that member state. But overall, what seems awkward about the current state of copyright is that there might be obstacles towards the adoption of an open norm. Why? Because there is no such thing as a system of EU copyright. There is still a territoriality principle which is alive and biting, in the sense that, for instance, if we take the fact that, first of all, in the EU there is no such thing as a doctrine of legal precedent. The only member states which have it are the UK and Ireland, but in other member states there is no such thing. So having an open norm might be useful, but to an Italian judge telling him or her that a case on a very similar factual background was decided in a certain way is not as strong as a statement as telling this to Mr. Justice Richard Arnold in the High Court of England and Wales. First thing. Second thing, there is no real dialogue among judges of different member states, and certainly having a judge from the Netherlands deciding a fair use case will not be of much help to a judge deciding a similar case in, let's say, Poland. Why? Because the copyright laws would remain distinct, so it will not be just a matter of interpreting whether a use is fair or not, but also whether how that particular copyright system, which is still national copyright law, should be interpreted. And finally, the main obstacle perhaps towards this, the introduction of an open norm would be the role of the Court of Justice of the European Union. Because the CJEU, when it comes to copyright cases, is not a judge of the facts. It is just a judge that interprets the law. So there will be references from member states asking about how to interpret this open norm, but the coordination role will be limited, lacking something that I think is the real elephant in the room here. That is the fact that the copyright laws of EU member states are still drawn along national borders. What I believe will be a good idea to make this open norm work as well as it could will be to go down the route of full harmonization of copyright at the EU level, thus overcoming the problems of territoriality and thus making the EU legal ecosystem suitable for an open norm. And is this something that is happening already? I think it is, at least since 2009, when the Court of Justice issued its decision on InfoPack. Since then, the CJEU has issued a number of cases which have de facto harmonized very important aspects of copyright. So EU copyright harmonization is already at a very advanced stage, and it will be about time that also legislative intervention in this sense is undertaken. And with this final thought, I would like to conclude and thank you for your attention.
Thank you, Eleonora, for your presentation. So now we have time for a very few questions. So does anyone have any question? If yes, please introduce yourself and your organization before you ask the question and tell which speaker you want to ask. Please, questions should be short because we have very few times. Okay.
Aspetta, fai prima l'intervento loro, se non ce la faccio.
Okay, so maybe before we start in the debate, then we have time for questions. So because we have a few minutes of the debate with, so I invite on stage Laura Ferrara, Member of Parliament, Committee on Civil Liberties, Justice and Home Affairs, and Dario Tamburrano of Europe of Freedom and Direct Democracy Group, Committee on Industry, Research, Energy. Please come here to have a debate, and then Giulia, you stay here because you are part of the debate, and and then Isabella Adinolfi too. Sì. Okay. Thank you to be here. So, a question for everyone. What to the member of parliament. So what do you intend to do to change the existing law, and what the citizen can do? Giulia.
I think one thing that is really crucial at the moment is making this entire debate much more public. I think, for example, when we see the debates in the different committees in the European Parliament, when, for example, people are saying that things like geo-blocking don't affect many people, and that it's only something that we as European bureaucrats care about because we happen to travel a lot. I think it's very important that these statements are heard publicly by many people, by all the migrants in Europe who are always affected by geo-blocking in their daily lives, or, for example, by linguistic minorities that have particular problems that are not heard in the European debate. I think in the European Commission consultation last year, we had a very good outcome. We had over 9,000 responses, specifically because civil society groups were encouraging people to tell the Commission about their specific issues that exist with copyright law, because we have to deal with the problem that some groups are much more well organized and have much more funding available to them. So I think for the public interest, it's very important that individuals can be heard and have easy access to their members of parliament. So in this regard, I would really like to encourage everybody to get in contact with representatives from their country or from their party directly, because it's really not that difficult to pick up a phone and to call an office of a member of parliament. And perhaps contrary to national parliament, this actually doesn't happen all that often. It's not like members of the European Parliament get calls from citizens every day. So this kind of direct approach and telling people to change copyright law and to fix the problems that exist, I think can really make a big difference, as we have also seen with the ACTA treaty that was largely defeated because a lot of people took direct action and contacted their members of parliament.
Giulia, do you want to say something on your platform, on a public platform? You have a platform to discuss the amendments. So what's the address and of the platform?
So when I published my draft report in January, I put every single paragraph from the discussion up on the discussion platform Discuto. This platform allows you to comment on particular paragraphs, to add proposals for new paragraphs, or also to rate the comments of others, or to say which points in the report are most important to you. Now, the link is available on my website, juliareda.eu, where I have summarized all the ways you can participate, and the amendment deadline, so until when members of parliament can propose changes to my report, was today, and I have taken 3 proposals from the Discuto platform that I think really add, for example, making sure that contractual terms cannot overrule an exception, that I've taken from Discuto and tabled as an amendment to really show that this has an effect also.
So the platform for the citizen is the horse battle for the Movimento 5 Stelle too. So now we would like to listen to Laura Ferrara. This is committee as a member of Parliament Committee on Civil Liberties, Justice and Home Affairs. Laura, it's on you. Okay.
Grazie, buongiorno a tutti.
Well, thank you very much. Good morning to everyone. I'd like to thank you for your participation this morning, particularly Isabella, who organized the event. I think it's been very interesting indeed. I'm a member of the Libe Committee, the Committee on Home Affairs and Civil Rights, and I'm also involved in the Jury Committee, the Legal Affairs Committee. I'm the shadow rapporteur for the EFDD group. Now, if you look at this file, in a way, the measures are already obsolete because of technological progress. But if you have a look at the initiative report on the review of the directive on copyright in the information society, I think that what we have before us is a real and not hypocritical attempt to keep up with the times. At the last meeting of the Legal Affairs Committee, when we discussed this initiative report, we saw that there was a clear effort to try and stall for time on this report, which I think could be revolutionary from a number of different viewpoints. Well, I think that this was made clear by the rather strong words from the Vice Chair of the Legal Affairs Committee. He said that Giulia Reda was heroic because she had ventured into a very dangerous task. Well, it really struck me the way he put it. I think it's a kind of psychological terrorism that he's trying to exercise over her. He's basically saying that if you have more harmonization and change here, then you might really change something. And he sees this as something dangerous. Well, what can we actually do here? I think we need to have the necessary courage to try and confront some typical issues that are constantly raised here, some taboos that quite often damage the final users, but also the authors of the works. Well, I'll remind you that the function of copyright is supposed to promote culture, knowledge, and things like that. Over the last quarter century, we've been confronted with a major digital revolution that's changed everything about our daily lives. I think that what the member states have been doing is using all of the legal instruments at their disposition to indulge in protectionism. I think the problem is that there is a proliferation of exemptions and things like that. That basically copyright is moving closer to patent law, basically creating barriers to prevent final users from access to the works. So whatever the piracy that's out there that might be on a commercial scale, but I'm wondering whether this excessive protection is sufficient to prevent illegal downloading and to basically give copyright its function, which is supposed to allow, as I've mentioned, access to art and culture. The authors, the intermediaries, the users, have we got the right balance between their needs and interests? Does the system as it is allow a democratic and widespread access to knowledge? We have to ask ourselves these questions. The 2001 directive, well, does it allow us to correctly respond to these kinds of questions? Does it allow us to move into the future? I think we need to have the courage to say that we need to make a change. And the path from author to user should be as short as possible. We need to ensure that cultural entrepreneurship allows authors to get into contact with the public. And I think we need to change the traditional paradigm for protecting the creative industries. I think that we need a full review of this directive. Of course, there's going to be a long road ahead of us, and there's a long road indeed between the creators and their public. I think that we need to simplify this as soon as possible. We need to bring the final user closer to the creators. This is important. There should be direct contact. If you go back to the analog world where intermediaries were necessary through cultural entrepreneurs, but well, back in those days, there needed to be companies to provide physical copies of the work so that they could be sold and transported and distributed, etc. But today, the digital revolution has changed everything. The digital revolution has changed the technologies we use to receive the works. Look at situations where the final user in real time can get access to the work I mean, if you compare it to television or video recorders, etc., these days you just need a computer or a mobile phone to get direct real-time contact between the creators and the final users. Well, what do I need to add here? The situation has changed. It's transformed completely, and it's difficult to manage the consequences of this transformation. We need to consider the role of the industry and the distribution chain for the works. Artists are now in a position to share their works directly with the public, creating a kind of one-stage distribution model. So what kind of legal protections are most appropriate in this kind of world? Is it on the basis of property rights or relative rights, copyright or copyleft? Or do we need both in one model or another? In recent years, the legal judicial situation has changed somewhat, and there's a lot of resistance among the cultural industries, even from artists and creatives. They're afraid of the unknown. They don't want to embrace a new route to marketing their works. So they're not ready yet, in many cases, to take a step towards a new kind of world. Now, I don't think that these objections make sense. In many cases, it's the artists who are paying for the consequences of an obsolete directive that's certainly at least anachronistic. Their rights are often limited by the existing legislation. I think that in many cases they could... they find that they earn a lot more from concerts and merchandising than they do from the actual rights to their works. As Mr. Ricolfi said, you've got two different competing systems of protection in place. You've got the old system of copyright, and then you've got a kind of copyright 1.0 and a new copyright 2.0. Now, in many cases, there are various kind of chip disclaimers. But now, authors under the copyright 2.0 simply allow the author the right to the ownership of the work, but very little else. So, I think that this would have to be applied only to certain cases. Under a copyright 2.0, I think that we would have to ensure that the duration would be sufficient for recovering the investment and until the obsolescence of the original work. We shouldn't abolish copyright, but update it. We don't need to replace the whole concept. The new one stands alongside the old one. So just adapting to the needs of the digital age. We could call this Creative Commons by default. Now, this would allow us to achieve the right balance between the two different requirements. We also have to remember that the principles behind copyright should provide incentives to distributing works and creating works. There is space for this in the report we've seen from our colleague Giulia Reda in Article 6 particular. She's talking about renouncing copyrights in favor of public domain. I think that this could do with a little bit more of a close look. We also do need to properly assess our revisions to the system. So we're trying to prevent the protectionist abuses that copyright is used for in many member states. But at the same time, we do want adequate protections and remuneration for authors. We also want to ensure that users get their access to cultural knowledge at the same time. So we face a crossroads. We need to decide, well, we're already looking forward to the next round of elections, whether we want to be protecting the strong economic interests or protecting future generations.
But did you present some amendments to Reda report or what? Cioè presenterete degli emendamenti?
Will you be tabling amendments? Well, the deadline was this morning at midday, and we have tabled amendments that go along the lines of what I've just said. I mean, we fully agreed with the report that was already been tabled by the colleague, and the amendments are really to support the content that was already in the report.
So Giulia, did you see some amendments of the other group? In a few minutes, because we have to finish.
Well, I've found that the cooperation with the different MEPs is quite different. Like, some of them came to me beforehand and said, okay, these are the particular concerns I have, and then tried to come to a common agreement, and others just table by themselves, and then we will have to try to find a compromise afterwards.
Okay, thank you. So now I invite to have a speech Dario Tamburrano, Member of Parliament. Dario is member of Europe of Freedom and Direct Democracy Group, Movimento 5 Stelle, a Committee of Industry, Research and Energy.
Salve, innanzitutto
Yes, well, let me begin by congratulating Mrs. Reda for the excellent report, and also the slides that we were shown. I think they were really excellent. They really help us to remember what she says. That was great. Now, I agree with Laura when she says that rather than worrying about the next elections, we have to worry about future generations in the world of culture when it comes to copyright and research, etc. And I think it really is important to look to the future and to try and see how this generation and the next will be able to deal with a world that is changing very rapidly. In fact, it's changing so rapidly that the legislative procedure with all its discussions, amendments, etc. Is perhaps not rapid enough. Now, I'm a member of the European Parliament, and given that, I will go back a little bit to my experiences as an activist prior to becoming a member. So let me tell you a little bit about the successes and the difficulties that we had dealing with the area of culture. Now, within our movement in 2007 and 2008, we started some groups to diffuse certain texts on the internet, which would have been difficult to distribute in Italy for various reasons, but which were important with regard to the various issues we faced. And our working groups were very successful, also because of a publishing house that really looked to the future. And so it meant that, for example, Lesson Brown's texts could be published in Italy. He's someone who's an economist, an environmental economist, who's well known across the world. And we managed to get the text translated by volunteers, which also helped. We were the 5 Star Movement and a translation group as well. And the point of all this was to give us the opportunity to put these texts on the internet. And the text started to circulate and actually boosted sales of the hard copy of the book. So this was a first in Italy in terms of a cultural and distributive effort being made between a group of volunteers and a publishing house. And I think that really showed that this kind of thing can be a success, and it doesn't cause problems when it comes to selling the hard copy of the text. Now, we found ourselves in a situation in which many people don't have the opportunity to have contact with culture, and so distributing these kinds of texts over the internet will help them to have access. In addition, we have a problem when it comes to small publishing houses, because they don't dare take the risk of investing in texts that aren't necessarily going to be blockbusting hits. And so we dealt with that issue a little bit, and we also came up with a platform which produced crowdfunding so that some works that had never been published in Italy could have some kind of access to Italy. And we believed that these texts were also essential for us to understand our present and our future. So we came up with this project, Community Support Translation and Publishing. It was along the lines of the other community support groups, i.e., for example, these cooperative farms, when farmers are funded by a group for the community to then receive the products it wants. And so we launched this crowdfunding idea to try and purchase the rights to certain texts to then be able to translate and distribute the ebook. in cooperation with various publishing houses. We did, however, find certain difficulties when we tried to do this. An initial problem was national in scope because crowdfunding wasn't very widespread in Italy at the time. And then we also needed bank guarantees to get into all this stuff. So once again, you had the banks involved in these social movements. And then there was also a problem relating to copyright, because when you launch a project of this kind on the internet, a project that aims to translate a text into various languages, where you have various copyright laws, various publishing houses across different European countries, etc. And so things became pretty complicated. So we saw how complicated things were and the need for a European law that regulates the copyright rules across various countries. I mean, this is something that could benefit authors as well, because many texts simply can't be distributed because of language problems or because of the copyright rules in existence. And these are sometimes texts that are of significant cultural, scientific or whatever value. I mean, the fact is that at the moment, culture is perhaps the biggest weapon we have to deal with a world that's constantly changing. Thank you.
Aspetta che non mi sento. Volevo chiedere agli interpreti se era possibile fare giusto 3 domande.
I was wondering if it's possible to have a couple of questions. Would that be possible for the interpreters? 5 minutes? 5 minutes allowed. Okay.
So, just a very short question, please. The first one was before. Okay. So tell to the speaker.
Yes. Super short, I am Carmela Asor, I work at JRC, and I would like to ask Beuk about those data given about levies and how they impact in the cross-border trade. Where this data come from? I'm interested in knowing that. Thanks.
Yes, actually it comes from I think it's a scoreboard. It was official data from the European Commission. I don't know if I put it in my slide, the reference. If not, I can send to you. I can show it to you right now. Thank you.
Okay. Other question? Other question? Here.
Thank you, Caterina Bortolini from Telecom Italia. I also represent ETNO, the European Association for Telecom Operators. A question to Honorable Adinolfi. In relation to her report, you mentioned in the very last but not least, unfortunately, point, the review of the liability of service providers. I'm particularly worried about that, even because very recently in France, the Minister for Culture tabled a proposal to review the copyright directive aimed at introducing a new general exception aiming at providing a fair compensation for all right holders that are unable to lodge a complaint according to the e-commerce directive. So my question is, do you believe that it could be a tool that you envisage to review the liability of the service provider? Thank you.
Well, we've had a look at this directive in terms of the copyright aspect, and in point 8, taking account of what's happening in countries like Italy, where you've got administrative authorities that are closing down sites. Well, we've heard about this from the speakers. They're closing down sites without going through any kind of legal authorities, the judiciary. I think this goes beyond the Charter of Fundamental Rights, and it should be not accepted.
Yes, thank you.
And the speaker,
yes. David Hammerstein, the Transatlantic Consumer Dialogue, which represents many consumers, including BEUC. I'm going to be very, very concrete. One of the issues we've worked upon which poses the question that common practice, common sense, morality, what people think in the street is on one side, and then governments, under the pressure of lobbies, whether they're socialists or conservatives take exactly the same positions, especially, for example, the Italian government, which has been blocking the ratification of the Marrakesh Treaty of an exception for copyright and wants to prolong the process of adaptation of EU law for 4 or 5 years, preventing millions of blind and other visually impaired people from around the world of exchanging books. So we reach a point where the immorality and the irrationality of the issues means that the European Union is delaying indefinitely the ratification that countries around the world which would allow the cross-border sharing of books through an exception and limitation of copyright. I'm asking, for example, all the Italian members here, have you taken this to your government or your national parliament, or why, for example, in the Italian presidency, every possible thing was done to delay the ratification and the access to culture
So,
of
which
blind
is the
people around
question?
the world?
Please tell the question to the speaker, because we.
What is being done? I hear in the European Parliament there will probably be a debate in the next one of the next plenary sessions. But what is being done, for example, on a national level? I'm asking the Italian members to change the positions of government, because the same thing is happening in France. They have a socialist government, but on exceptions and limitations, nothing is.
Thank you.
Beh, noi in Italia siamo all'opposizione e...
Well, in Italy we're in opposition. And I mean, if there is a process going on where democracy is being lost, it's certainly happening in our country as well as everywhere else. So we're constantly coming up with proposals that are being rejected because, as you said, the centre-right and centre-left in Italy, as in this parliament, legislate in the same way in spite of what the citizens want. So, well, unfortunately we're in opposition. Thank you.
Facciamo anche cose come questa, come
And as members of the European Parliament, we come up with events such as this hearing, which is being web streamed, to ensure that debate is as wide-ranging as possible, and of course to raise awareness among the general public. I mean, I think all members who are here do their very best on a daily basis to take decisions which are as independent as possible, and also decisions for the common good. I don't think anyone can raise objections to that. I do apologise, says the speaker. The interpreters do have to leave now. Thank you.
So I think that we finished the conference, and dear guest speaker, ladies and gentlemen, I wish you thanks for being here with us, and I hope to see you soon for another conference on copyright. Thank you.
Vado un attimo a firmare il foglio degli interpreti.